पीछे एक और क्वेश्चन लगा तो पीछे एक और क्वेश्चन लगा ये पीछे हो yes
May it please your lordship, I seek your lordship's indulgence in mentioning an item number 6 from the daily cause list, your lordship. Item number 6.
yes
Your lordship, the AG is supposed to be appearing today. Unfortunately, he's not. He will not be arriving on time.
Okay.
Therefore, this matter may be listed again on the 30th of April, your lordship. I've taken the consent of the other party as well.
okay a request has been made on behalf of the learned AG for taking up this matter on when 30th
30th April, yes, your lordship.
30 April 2026 request allowed list again on 30th of April 2026
Your Lordship, there is an interim stay, and may it kindly be continued.
the
until
interim
next-
stay continues interim orders passed earlier continues
Much obliged, your lordship.
Yes, your lordship's indulgence in mentioning item number 7 of part 2, my lord.
7 of part 2
Yes, my lord. If the matter be taken up after 2 weeks. If the matter may be taken up after 2 weeks.
Thursday
No, after 2 weeks, my lord.
after 2 weeks
Yes, I've taken the consent of the appellant.
the request made on behalf of the respondents with the consent of the learned counsel for the appellants list this matter again after 2 weeks
Right, my lord.
Daily list for motion, item 1.
yes sir
May it please, Your Worship. Your Worship, the main grievance of the petitioners is that they were working on regular basis under the erstwhile State Social Welfare Board. And due to the decision taken by the central government to close down the Central Social Welfare Board, as well as the State Social Welfare Boards, both the central as well as state social welfare boards have been closed down. And the Central Social Welfare Board and the central government had requested the state respondents, directed them that the petitioners working in the State Social Welfare Board should be absorbed, and the regular pay, pension benefits should be carried on.
okay
But in spite of that, Your Worship, the state respondents have taken the decision to absorb the petitioners, but they would not be entitled to any claim for pension. And after that, in spite of the decision to absorb them by the Council of Ministers, instead of absorbing them, they have been accommodated to equivalent posts under the state government. And although they're being paid, although it was decided to give them pay protection, their pay level as well as their basic pay has been reduced.
okay
From a part of, and also that the pay from June 2023, from April 2023 to June 2025, only 50% was paid.
oh
So we have challenged the decision of the state respondents to decide that we won't be entitled to claim pension. That has been challenged, and the decision to,
but that was a service under the board
and Your Worship, under the state, according to the service conditions, 50% of the pay was given by the central, 50% by the state. And after the closure of the State Social Welfare Board, the central government had directed that the pay should be given by the state government and they should be absorbed.
so
And
now that state which had a responsibility of 50% that is what they have paid
yes,
it appears like
yes, it appears that.
that. Okay heard Mr. A.R. Malhotra learned counsel is paying for the petitioners also A.R. Malhotra learned counsel is paying for the petitioner this writ petition has been filed with a grievance that although the petitioners were required to be absorbed into the services of the state of Mizoram on the closure of the
State Social Welfare.
Central Social Welfare Board and the Mizoram State Social Welfare Board, they have been accommodated in the state services, in the services of the state. Full stop. The further grievance is that there is no indication regarding the pensionary, have they said you will not be entitled to
Yes,
pension?
they have said that we will not be entitled to it.
The further grievance is regarding the rejection of the benefits of pension to the petitioners on their being accommodated. And a limited grievance is also raised regarding the withholding of 50% of the pay of the petitioners from the period, for the period from April 2023 to June 2025, full stop. Issue notice, returnable 4 weeks. Who appears, madam?
I am appearing for the respondents 1 to 6.
Miss so-and-so appears for the respondent number 1 to 6. Madam so-and-so appears for respondent number 7 and 8. Since all the respondents are represented, formal notices are formal steps are dispensed with. However, extra copies of the writ petition be supplied to the learned counsel appearing for the respondents within a period of 7 days from today. List this matter again on 14th of May, allowing the respondents to file their response. On the next date fixed, the respondents shall invariably inform this court the reason for withholding 50% of the pay of the petitioners for the period from April 2023 to June 2025.
I'm okay.
Item 2.
Yes?
My lords, here, my lords, we are seeking regularization, my lords. We are 13 petitioners.
Ah,
We've been appointed against sanction post in the Aizawl Judicial District for the posts of stenographers, grade 2 and grade 3. Now, my lords, we've served for more than 10 years. And my lords, even in fact, this proposal for regularization, my lords, the administrative committee of this honorable court had also, my lords, approved for the regularization. That is at page 63, my lords. The agenda meeting is there. Your lordship sees. Page 63, my lords.
where is this order which you are challenging?
My lords, your lordships may have.
Fair one,
Yes, my lords. Your lord-
29/11/2022,
My lords, page 91.
21.
91. 91A is the true type copy, my lord.
Does it say with regard to the proposal of regularization of regularization of census? So now they say they can regularize.
Yes, my lords.
It also refers to some direction of the High Court.
Yes, my
What
lords.
was the direction?
My lords, the direction was the approval accorded for the purposes of regularization. My
Where is it?
my
Is
lords,
it
that is at page, if your lordships had page 65. The operative part, my lords, at the end. And it runs to,
This is part of what?
my lords, the agenda meeting placed before the administrative committee of this honorable court.
Of the court.
Yes, my lords.
Which is the relevant agenda?
My lords, agenda number 4.
4.
It starts at page 63.
Okay. Just give us 1 minute. So the High Court expressed no objection.
Yes, my lords.
Now what do they say?
My lords, in the
However, appointment was given on ad hoc basis in the department session committee was considering. But this was not a promotion committee. Why are they coming up with a promotion committee at page
My lords,
91?
that is for the respondents to answer, because as your lordships has said, my lords, it's a selection. And my
Everything
lords,
is selection has been done.
yes. And my lords, it is a 3-tier process, my lords, involving written test, interview, my lords. It is not an illegal appointment.
Merit was considered.
Merit was considered. Now, my lords, I must come clean in one aspect. My lords, post 29/11/2022, which your lordships has read, rejecting the proposal. My lords, I believe because of, I cannot say, but my lords, these documents are very limited as provided by the clients, my lords. It has led to further, my lords, deliberation, which your lordships would see at page 92. This is the, my lords, registrar of this honorable court's letter. Further discussions seem to have been held in this regard, my lords. And ultimately, my lords, at page 94A, this is the true type copy, is the, my lords, further order by the government, whereby they have reproduced the observations of the specific department, again rejecting the proposal for regularization, which we are challenging.
Heard Mr. So-and-so and counsel appearing for the petitioner. The grievance raised in this petition is against the office note, against the communication, against the office notes dated 29/11/2022, 16/12/2025 and 14/1/2026, whereby the intention of the respondent authority has been expressed declining the proposal for regularization of 13 of how many stenographers?
13, my lords.
13 stenographers post of the learned counsel for the 13 stenographers serving in
Aizawl Judicial District. grade-
Aizawl Judicial District.
Yes, my lord. Grade 2 and grade 3.
13 stenographers serving in grade 2 and grade 3 posts
Yes.
within the Aizawl Judicial District. Full stop. The learned counsel for the petitioner has submitted that the petitioners had been appointed after a due selection procedure had been followed, and therefore, in view of the resolutions adopted by the administrative committee of the Guwahati High Court, the petitioners deserve a consideration for regularization of their services. Full stop. Issue notice returnable 4 weeks.
My lords, we are also seeking some interim protection.
Returnable 4 weeks. Miss so-and-so appears for the respondent number.
State respondents, Your Lordship, 1, 2, 3, and 5.
3 and 5. You are appearing for?
My lord, I am standing counsel for Mizoram Public Service Commission,
Okay, Mr. So-and-so.
and this is the
appears for
first time I come to know. I'm appearing for Mizoram Public Service Commission, and my junior will receive the petition on my behalf, Lordship.
Mr. So-and-so appears for the respondent number 4. What about
I'll be appearing for respondent 6 here.
6? What about 7? No.
My lords, 7 and 8, my lords, we've given an undertaking, we'll serve, my lords, because we don't know.
Respondent number, Mr. Malhotra represents the respondent number 6. Full stop. Formal notices to these respondents are waived due to their representation in the court. However, petitioner shall serve extra copies on the counsel for the respondents within a period of 2 days.
My lords.
Steps on the respondent number 7 and 8 be taken through speed post within a period of within 22nd of April
My lords.
2026. Full stop. List this matter again on 15th of May.
My lords, no difficulty, my lords.
15th of May? On 15th of May 2026, allowing the respondents who are represented to file their response and the respondent number 7 and 8 to cause appearance on their behalf. Full stop. In the meantime, it is provided that the services of the petitioner shall not be disturbed without leave of the court.
My lords. Grateful.
For admission, item 3.
Lordship, the respondent number 2 have filed their affidavit. However, Lordship, at this point, I would like to go through the affidavit properly. So if this matter can be taken up on some other day, after vacation.
An additional affidavit in opposition has been filed by the respondent number 2 recently, and the learned counsel for the petitioner has prayed for an accommodation to acquaint herself with the contents of the affidavit and affidavit full stop. Accordingly, list this matter again on
28 April.
28th of April. Mr. So-and-so appears for the respondent number 2. Madam appears for
Number 1.
respondent number 1.
Item 4.
Lordship, I seek some more time to obtain further instruction whether to file an affidavit or not.
Whether
To file an affidavit in opposition or not. May the matter be taken after vacation.
any interim orders operating?
Yes, my lord.
Mr. So-and-so and counsel appearing for the respondents. You appear for all the respondents?
No, my lord, 1 to 3.
Appearing for the respondent number 1, 2, and 3. Prays for an accommodation to have instructions regarding filing of response to the writ petition. Full stop. There are only 3 respondents. What about the others? What about 4, 5, and 6?
Lordship, basically they are pro forma defendants. They are the acting VC members appointed by the respondent number 1 to 3.
No, has it been concluded? Has this service been concluded on them?
Yes, my
No,
lord.
my lord.
Huh? Okay, as per the note of the registry on 142026, the service of notice on respondent number 4, 5, and 6 was completed by delivering the notices on 27/12/2025 full stop. However, there is none to represent respondent number 4, 5, and 6. Learned counsel appearing for the respondent number 1, 2, and 3 has submitted that the said respondent number 4, 5, and 6 are pro forma respondents who were the members of the temporary, of the,
Members of the village council
member-
appointed by the respondents.
were the members of
1
the
to
village
3.
council who were appointed by, in place of the petitioners, full stop. List this matter again on, give us a date,
After vacation, my lord.
give us a date,
Any date.
choose a date.
Lordship, if it is possible, on 24th of April.
24th of April
April. Yes, my lord.
2026, allowing the respondent number 123 to file their response if so advised. The interim orders passed earlier shall continue.
Obliged.
Obliged, my lord.
Item 5.
Wait, please, Your Lordship. Your Lordship, order dated 18/3/2026, wherein it was stated that the interim prayer may be considered in next returnable date. So today is the consideration of the interim prayer.
You are still attending office?
No,
You are
Your
taking
Lordship,
classes?
we are terminated by
But
the.
status quo was required to be maintained. They
Yeah,
are not
the
allowing you to take
status
classes.
quo with regard to the vacancy of the thing is,
Okay.
we are already terminated, Your Lordship.
Yes, madam, what is your instruction?
Yes, Your Lordship, as per my instruction, in the present case, the petitioner were terminated based on the so-called notice. And there is no violation because they have given ample of time
No.
to have that qualification.
No, 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 no.
And
That
Your
is-
Lordship, as per page number 72 of the application, the petition, it is clear that they were given ample of time. And
No.
the reason why they were terminated is that they did not acquire the required qualification.
Your Lordship, in our contention, we have not given time for that since we are already exempted for having net and slat. So recently, in 2025, they came up and where we don't have net and slat, and we have
Where is
stated
your regularization order?
we are not yet regularized, Your Lordship. We are contract.
Huh?
Contract.
Where is your appointment?
My appointment is kindly see 46. 46 and 54.
What was the advertisement? Advertisement?
Advertisement, Your Lordship, it's in 44. Lordship got it. Here, exemption is clearly mentioned. Page 44, Annexure 4. Kindly see serial number 3
Ah,
here in the column. Master degree in the subject with at least 55 marks. Relaxation up to 50 marks for SC, ST. SLAT MPhil qualification exempted as approval of the government. It's clearly mentioned here. And just before that, Your Lordship, just before that page 43. Kindly see that in the,
exemption was required because they were not finding any people.
yes,
Yes, okay.
page 43, column 2. If there are no qualified candidate as per UGC, AICTE norms, advertisement should be floated for the second time. So first time they have floated, so no qualified person was found. So again, they have floated and exempted the qualification of net. So this is the advertisement.
Just a minute. When was the last time your agreement was extended?
Extension, the last time is
On
Page.
10 February 2025, that is in page 72.
Page
72.
72.
72.
They have said that we are unqualified, even though the advertisement says that exemption was given.
The UGC norms say it can be net, SLET or MPhil,
Yes.
and persons with the PhD are exempted. So now there is an application where on, what is the date? 29th of October 2024, where they say they are pursuing their PhD. Then why this sudden abrupt
No, actually,
termination?
Your Lordship, there is a notification that they have to acquire the qualified
No.
education,
what-
qualifications.
What
That they have to
qualification?
UGC
have-
norms, as far as we understand,
Yes, Your Lordship.
UGC norms say that you have to be net qualified or state level qualified, SLET or MPhil, and
Yes, sir.
persons who are PhD, who hold the PhD degree, they need not have MPhil also. So for PhDs, net, SLET and MPhil all are exempted. Now these persons had filed an application on 29th of October 2024. Is it not?
Yes.
At page 71. Now they are saying that they are pursuing PhD.
Yes, Your Lordship.
If they can complete the PhD, Nestle would know, Nestle MPhil would become.
That regard, Your Lordship, in that regard has to be rebutted as per affidavit. Right now, we are concerning regarding the interim. So with regard to the interim, Your Lordship, my submission is that if we grant the interim order at this time, it will be like reinstate of the petitioner, which is impermissible, Your Lordship. So the reinstation or whatever has to be done after the final judgment. So at this time, this is the interim order. If the interim order is passed, prejudice may be caused to the administration. So my humble submission is that in this regard, an interim stay order or status quo may not be permitted.
Your Lordship, with regard to similarly situated person, Your Lordship, while regularizing their service, they were exempted also. I have enclosed.
Where is that exemption?
Kindly see page, Annex 25, page 87. And the operative portion, page 88, the name is Lalom Zwali. You got it, Your Lordship, number 1. List of regularization, page 88. 1, Lalom Zwali. Here in the bottom, page 90. Page 90, kindly see page 90.
Just,
Here it says.
just a minute, madam.
Yes.
Page 90.
Yes, in the bottom second para. Further, as per DP and AR such and such, dated 11/10, the regularization of E. Lalomzwali, Department of History, is subject to the condition that she must obtain net SLED within a period of 3 years from the date of her regularization. So they have given the time. After regularization, they've given 3 years to acquire net. And again, there are 2 more persons they have exempted again. For
What
regular,
is para 92, page 92?
page 92, Your Lordship, yes, these 2 persons, they don't have, these 3.21 of UGC regularization is the, regulation is the, about the net and the qualification of net. This is exempted also. These 2 persons, they have regularized. So
Yes, madam.
they are, this, we are working as 26 years, Your Lordship. We are 50 above our age. We are,
Tell us. 2 options. 1, we allow them to work. 2, the second option is file your affidavit as soon as possible.
Yes, Your Lordship, I will file my affidavit.
And till such time, don't fill up those posts.
Yes, Your Lordship.
Because not only have you allowed others time, you are relaxing them before their regularization, and in certain cases, after regularization, you are granting time. How can that be? And PhD at the age of 50, passing net and slate at the age of 50, humanly possible. Huh?
And in that case, Your Lordship, if status quo may be maintained, and I may be granted time to file my affidavit.
Heard, Miss.
Your Lordship, kindly, the
Now, what interim order?
early disposal will be required. Otherwise, there,
Disposal today.
no, early disposal. Let them file.
We'll have that. Don't worry. Heard Ms. So-and-so and counsel appearing for the petitioner. Also heard Ms. So-and-so and counsel appearing for the respondent. For all the respondents. The matter was fixed today for consideration of the interim prayer. Full stop. The learned counsel appearing for the respondents has prayed for an accommodation of 2 weeks to file the affidavit in opposition. Suggesting that an early disposal of the entire matter would be more feasible than granting an interim protection at this stage. Full stop. The learned counsel for the petitioner has submitted that the petitioners had been serving
More
For
than,
more than
20 years.
20 years, and the sudden termination requires an early interference. Full stop. The learned counsel for the petitioner has drawn attention of this court to the notification dated 29th of February 2024, by which a similarly situated candidate, a similarly situated incumbent in the working in another college on contractual basis had been regularized as an assistant professor within bracket contract, comma, giving her a further period of 3 years from the date of her regularization to obtain the net set or slit from the date of her regularization. Full stop. The learned counsel for the petitioner has also drawn attention of this court to another notification dated 13th of December 2019, whereby the eligibility condition under para 3.3.1 of the UGC regulation 2010 was relaxed in respect of the two contract assistant professors serving in Government Science College. Full stop.
And they are regularized.
Where is the regularization order?
Your Lordship, recommendation is there
Huh?
in the last page, Annex 27.
The Illinois Council for the Petitioner submits that pursuant to such relaxation being afforded, the Meghalaya Public Service Commission has also recommended the regularization of the aforesaid two professors. Full stop.
At this stage, they are already regularized.
She further submits that pursuant to the recommendation, the said assistant professors have been regularized in service. Full stop. Prima facie, it appears to this court that the petitioners have been meted out with injustice when when a person similarly situated had been afforded regularization with relaxation and extension of time, and further when other similarly situated persons were granted an exemption in the zeal of the government to regularize such persons. Full stop. The petitioners already stand terminated by the order dated
By the order dated
232 by the order signed by the director on 2/3/2026,
yes.
and therefore a reinstatement at this a reinstatement in the form of a interim protection would not be feasible at this stage. However, it is made clear that in the event the petitioners succeed in the writ petition, the respondents would be they succeed in strike out that line. However, it is made strike it out. We said, what did you say the last line? May not be feasible at this point of time. Full stop. Accordingly, the writ petition is directed to be listed again on 15th of May. Yes?
Yes.
Or no, 15th of May will keep it on 14th of May.
Yes.
14th of May 2026, by which time the respondents shall ensure the filing of the affidavit in opposition, filing their response by way of an affidavit. Stop. An attempt would be made to take up the matter for disposal on 14th of May. Stop. In the meantime, the respondents would not initiate any steps to fill up the posts earlier held by the petitioners without leave of this court.
Much of
Item 7.
Your Lordship, in this matter, I'm counsel for the petitioner.
Yes.
So, my lord, these matters need quick disposal as urgent. So they have to file their counter affidavit. I contact them this morning also. They have to file. They are filing their counter tomorrow, it seems.
What is it?
My lord, here we challenge. One thing is that we have been evicted from our locality. We challenge the eviction order first. We are accused of murdering, yes, a lady, and then because of the PR, so then the NGO, they issue eviction notice, and also we pray for compensation for demolition, burning of our village, our house also, and also registrations of criminal case against the culprit.
Just a minute.
If you kindly see the first order, it is very clear. 24th February 2026.
You have not filed your response?
Your Lordship, we are yet to file a response. I'm yet to receive the instructions. If time may be granted, Your Lordship, to file the
Now,
affidavit.
just see this, the prayers are for what?
My prayer is for,
You are appearing for whom, sir? You are appearing
For the
for?
respondent number 5 to 8,
Who are they?
all in Geo. Respondent number 5 to 8.
Yes, you have issued the eviction notices.
See, Lordship, actually, it was due to fact in order to calm the public anger. So just exactly, it was not the eviction notice. It was just a statement.
Where is that notice?
my lord, if you kindly see that annexure number 4, page number 35, how can they say this is not eviction notice?
Which one, page number?
36,
36.
yes.
Yes. How do you make
Even
such statements?
subsequent, Your Lordship, after filing this case also, they issue another publication also.
Where is it?
My lord, that I would like to file rejoinder also.
Why do you wait for a rejoinder? You should bring it on this thing. Yes, are
Definitely,
you
I'll-
authorized to make such statements that this man will not be allowed to stay here when he has got his own property there?
No, my lord.
Huh?
No, that the petitioner has been living in a rented house.
Yes.
Then near the rented house,
Murder took place.
yeah. So
And
they,
you all suspect that this man is the murderer. And so
Yeah.
you'll ask him to leave the property.
no,
They,
actually,
know, they burnt their house also.
before,
Huh?
They burnt my house also.
They burned down the rented house. Someone else's house.
No, no, my
burned
lord,
down.
not rented house. I was constructing, my husband was constructing a house nearby.
So, my lord,
That house, they burnt it. They damaged even my vehicles also. They burnt in my vehicles also.
Yes.
Lordship, the respondent 5 to 8 are leaders of the community.
Huh.
So we had given best efforts to protect from the public anger. So we try to prevent for the destruction of their properties also. Then during the incidents, people are shouting if the leaders of the community if may not do something. So we just made a statement in order to calm down the public anger. So it's a just
It
statement.
does not appear to
So
be an attempt to calm.
before filing this writ petition, the petitioner already obtained migration certificate from our locality. So it cannot be regarded the violations of their rights also. In their own ways, they already obtained the migration certificate also.
It is one thing to say
Yes,
that
my
you
lord.
will not sit in that chair because you don't want to, and it is another thing to say that someone will ask you to get up and go somewhere. Two different things. Had they exercised their own will to migrate, it's a different issue. But you asking them to leave.
No.
As a society, and see, it doesn't appear to this court that it is an attempt to calm down the public. It is an
Yeah,
attempt to retain
Lordship,
your power,
Yeah,
to retain your leadership.
That the statement was not served to the petitioners.
To whom
They
was it
just
served?
made a resolution. Then they posted at the WhatsApp information group. In the WhatsApp,
They
only
instigate,
WhatsApp.
that instigate the people, the public, and they burnt my house.
No, it's not the instigating. So
No, my lord, it's exactly.
the matter is,
Circumstance tells
in order
everything.
to calm down the public anger during the incident.
How can they calm the public by using such kind of statement? And even their subsequent conduct after filing this case also will speak, will
So
be very
should
clear.
we, when did you receive your notice?
Lordship,
Ah.
may time for filing affidavit in opposition. So all my content,
But we are going to restrain you from issuing any further public notices of any sort with regard to
Yes,
this
I lord.
incident.
is my lord.
Huh? No further, what
So-
do you say? Trying to calm down the public. Let the police do their work. You need not calm down any public. Huh?
But the real intention is not evicting the petitioners.
What is the petitioners?
Petitioner's family.
Ah.
We didn't try to evicting the respondent.
Then let
Sorry,
them withdraw,
petitioners.
let them withdraw their notice also.
Okay. Yes, madam, why is it taking your officers so long a time to file a response to this?
Your Lordship, I will.
There has been a murder.
Yes, Your Lordship.
Definitely it is being investigated.
Yes, Your Lordship.
Now, someone's property
Yes,
has
Your
been
Lordship.
damaged.
Yes, Your Lordship.
Has any FIR been lodged? Have you taken up the investigation? Who did what?
The investigation is ongoing, is what I have been told, Your Lordship.
There is an FIR, then there must be an FIR. Without an FIR, there can be
Yes,
no,
Your Lordship. Yes, Your
no
Lordship.
investigation.
Investigation is going on, Your Lordship.
So when can you bring those records?
Your Lordship, I will be able
Because
to.
because notice was issued in February, was
Yes,
it
Your
not?
Lordship.
We are now at the middle of April.
Yes, Your Lordship. I will inform the Home Department as well as the other concerned departments
You,
as
on
well
the
today.
next date fixed, it is either an affidavit in opposition
Yes, Your Lordship.
or a status report. We'll say it like this: an affidavit in opposition with a status report as regards the FIR, if any has been lodged, and the stage of investigation.
Yes, Your Lordship. Yes, Your Lordship.
And in the absence, the concerned SHO,
Yes,
what
Your
do you call it here? The in charge of the police station under
we
which
call it
this took
OC.
place,
Yes,
incident
Your
took place. He will be present in the court to explain. We are not saying that he should, was it done correctly or not, nothing of that sort. What we are trying to find out is, there was an incident,
Yes, sir.
house was burned down, vehicles were broken. Are you taking up any right zeal?
Sorry, Your Lordship.
Whether you are taking up the investigation in the right zeal when someone's property has been destroyed,
Understood, Your Lordship.
to that extent. And
Yes,
the
Your
Supreme Court, it appears, has asked you
Yes,
to do that.
yes, Your Lordship.
Heard Mr. So-and-so and counsel appearing for the petitioner, also heard Ms. So-and-so and counsel appearing for the respondent, and Mr. Your name, sir?
Mr. Robert Lieutenant.
Appearing for the respondent number 5, 6, 7 and 8.
Yes, my lord.
Full stop. The learned counsel for the respondents have prayed for an accommodation for 2 weeks to be allowed to file, to enable them to file their response to the writ petition. Full stop. It is noticed that the allegations in the writ petition are regarding damage of property, both movable and immovable, and also the illegal, alleged illegal and forceful eviction of the family of the petitioner from the locality in which they were residing. Full stop. The learned counsel for the petitioner has also prayed for an early disposal. Full stop. Early disposal in view of the allegations level. Full stop. This court allows the prayer of the learned counsel for the respondents for time to file their response to the writ petition. Full stop. Response to the writ petition be filed on or before the 28th of April 2026. It is made clear that in the absence of affidavits on behalf of the respondents, this court may be constrained to draw adverse inferences. Full stop. It is also made clear that the affidavits, the affidavit to be filed on behalf of the respondent number 3 and 4 shall state specifically the nature of the action initiated on receipt of information regarding the damage to the movable and immovable property of the petitioner, and also the stage of investigation. Full stop. Mr. So-and-so and counsel appearing for the respondent number 5, 6, 7 and 8 has made a specific statement before this court that the aforesaid respondents whom he represents do not have any intention of causing any disturbance to the petitioner, but the notices which they had issued through the WhatsApp groups was an attempt to pacify the agitated mob and the prevalent situation. Full stop. The respondent number 5, 6, 7 and 8 are directed not to issue any further private or public statements regarding the issue during the pendency of this writ petition.
My lord, please allow us to file rejoinder in the meantime. Rejoinder to
the petitioner would be at liberty to file their reply to the affidavits filed by the respondents, if so advised, on or before the 6th of May 2026. Full stop. List this matter
Well,
again. Yes.
One simple prayer I would like to make, if your lordship permits, because my lord, this is very clear that criminal case. But normally this is a rarest case in Mizoram. So at the very fourth page, we put civil extraordinary jurisdiction and writ petition civil it is written, as we have the practice in Mizoram. So kindly allow us to have amendment instead of civil, criminal in the page number 4.
No, even if it comes up as a civil writ petition, we can exercise our jurisdiction to enforce the lodging of an FIR and appropriate investigation, even in a writ petition civil.
Definitely, but if it is criminal, it will be more
No, that will give another angle to the whole issue.
Okay, then no issue.
Converting
Not
it into a criminal case and all that. You see, you understand, we understand. But
Yes.
when it goes out in the public, then it may give rise to another angle, which will again agitate the whole issue.
That's not an issue, your lordship. That's fine.
So we keep it as we don't change the nomenclature now. What did you say? Liberty to file their affidavit in reply on or before the 6th of May 2026, hai na?
Yes,
The
sir.
matter will be listed again on 12th of May for further
My lord,
consideration.
this may be listed on 21st May.
Huh?
My lord, that 28, you have written that, that order that
28, they would,
28,
they will file their affidavits on or before 28th.
yes.
So now if they file it on 27th, by when will you file your
Okay.
reply?
Okay,
So I
that's
have
fair
given
enough.
you
If they
another
are,
3 days to file your reply. Once the reply comes on board, we can have it on Tuesday,
that's good, you
on a
know.
hearing day.
But they should make sure that they file it.
That is what we have said, we'll draw in our adverse inferences otherwise. Read the order, anything
Yes,
remains, come back with an
good order,
application,
Lordship.
we'll add whatever is required.
Sure. Much obliged, your lordship.
Item 8.
May it please your Lordship.
Yes, sir.
I had submitted a prayer for withdrawal with liberty to file afresh. My learned friend, I think, had some hesitation, and he had said that he'll get instructions from his senior.
So, my lord, we have no objection.
You don't have any objection?
Yes, my lord.
Or do you have objection?
No objection, my lord.
No objection. So we'll allow it.
Yeah.
Learned Counsel, Mr. A.R. Malhotra, Learned Counsel appearing for the appellants, has prayed to be, has submitted that he is under instructions not to press this RFA in its present form and that the appellants would like to withdraw this RFA with the liberty to file afresh. Full stop. The Mr. So-and-so learned counsel appearing for the respondents.
Respondent number 2, man.
Respondent number 2. Who appears for the respondent number 1? You also don't have any objection? The learned counsel, Ms. So-and-so and Mr. So-and-so appearing for the respondent number 1 and 2 respectively have not objected to the prayer made on behalf of the appellants. Full stop. Accordingly, this RFA is closed on withdrawal, granting liberty to the appellants to approach this court afresh. What about the limitation part?
Subject to law of limitation.
Huh?
Subject to the law.
Subject to the law of limitation.
Item numbers 9 to 25.
May it please your lordship,
Yes.
this matter pertains to whether the act of the parliament can be override by the guidelines of a JICA, who is the funding agency. The facts of the case is that the
This similar matter had come up some days ago. Is it the same matter?
not,
The amount of
yes,
compensation
has been reduced.
it's been reduced.
Yes.
The Zyka matter, when was it? Tuesday or Monday? We have fixed a date for it.
Case.
Similar matters.
It's
The counsel
kind
for
of,
the Zyka, the
Yes.
counsel for the Zyka had appeared
yes, my lord.
and has made a statement that the guidelines of the Zyka will not override
Yes.
Yes,
the law of the land.
yes,
These are only guidelines, and these guidelines will only apply
yes.
after the project is initiated. So therefore, if this matter is listed along with that matter, where the Zyka Council appears, I
Yes, my
think
lord.
you would have a better stand. Because there Zyka
my
has
lord.
been implemented as a party
Yes.
by the orders of the court,
Yes,
and
my
they are to file their response.
Yes, my lord, earlier that all these matters has been taken together along with that case. However, they were segregated on the ground that in all these writ petitions, we have challenged the notification of the government, whereby the state government had decided to apply the JICA guidelines. Whereas in that case, no challenge has been made against the notification of the state government.
What we were proposing is not tagging the matters together,
Uh-huh.
but taking up the matters on the same day,
Uh-huh. Yes, my lord.
so that the Zyka Council can also
Yes, my lord.
respond.
They were not a party here in
They are not a party, but we'll have their response in the other writ petition. They'll
Yes,
be
my lord.
present.
Yes, my lord.
We can at least ask them what is the position.
Yes, my
We
lord.
can have their statement recorded because we can take judicial notice of it. They are present in the court. We can ask them about it.
Uh-huh.
But here, and maybe a decision in this case will help that case also.
Yes, my lord.
What do you say? The birds of a feather flock together. Yes, heard Mr. So-and-so learned counsel appearing for the petitioner. Also heard the learned counsel, Ms. So-and-so appearing for the respondents. Full stop. These matters were earlier tagged. Where is that order by which it was separated? Is there any order here?
My lord, it will be there, but I'm not exactly sure of the date, my lord.
Okay. It has been submitted that other matters where the rule of the Zyka, JICA, Zyka, and its notification and the impact of the notifications on the land acquisition proceedings involved are similar. Full stop. This court is of the opinion that although the other matters may not require to be tagged with this comma, since the other matter, namely WPC number, there was an IA by JICA, What is the WPC number? The other matter, namely IS civil number in WPC number are listed on, comma, these matters may also be taken up on that day for
Admission hearing.
for ease of adjudication. Full stop. Accordingly, list these matters again on 28th of April.
Lordship, in the meantime, reply affidavit may be filed.
You petitioners want to file.
Yes.
The petitioners herein would be at liberty to file their response
Yeah.
to the affidavit in opposition filed by the respondents, if so advised.
Item 26.
May it please your lordship.
9 to
May it
25
please, Your
go.
Lordship, on behalf of the PP,
Yes.
Your Lordship, on behalf of Mrs. Linda, the PP, if this matter may be passed over for a while, Your Lordship, because she's on legs in the other courtroom at the moment.
I think she's here.
Oh, she's here.
Should I make myself, the learned PP is there?
I'm here.
She's here. Yes, madam.
Yes, my lord.
My lord, the main grounds, my lord, as pointed out by my learned friend, is section 48. Yes, that he does not understand the language. My lord, I have produced the grounds of arrest under section 47. The lordship will see that everything was explained to him in English, and he has also stated that he understood everything, every word, and he has given his signatures.
47 is fine.
Yes, and 48, my lord, will see that the wife was contacted through the phone because she was in Manipur. And this was spoken in English, and she understands the language. And right after
She
that,
understands this language.
English, my lord.
But this is not in English. At page
15:15.
Mr.
15A
Biswas.
is the
Yes.
Mr.
translation.
Biswas, your filing assistant here has to be more careful.
Yes, my lord.
The paginations.
Yes, it's in the down below. That's even I found it. a
Down
bit
below is
awkward.
15A. There is no page 15. The original, the photocopies do not have any page number. Only the type copies are having page numbers. I don't know.
I'm sorry for that, my lord. I'll instruct. That
Anyway.
just the page.
Anyway, we'll overlook that. Yes.
Yes, my lord. The English translation, my lord. You, Hamkoton Tautang, son of so and so.
No, who has given that in English translation? Was it sent to the family? That is what we are asking.
It's not sent because,
Then-
my lord, they were informed
How?
through telephone. And your lordship will see that I have also produced a citation of this honorable court.
Please.
This is in case Bill Application 8 of 2026. At page, my lord, para 20 onwards.
Para?
Para 20.
20 years.
Further, my lord, let me read.
Yes, sir.
Yes, my lord. Let me read para 20. Further,
Para 20.
yes, my lord.
Please.
Further, it is seen that it may not be possible for the IO to issue notice immediately after arrest of the petitioner under Section 48 BNSS, as his family members, friends, or relatives may be residents of Tripura, as the accused is a resident of state of Tripura. From the arrest memo as well as from the seizure memo, it is seen that the IO made contact with the family members of the petitioner and intimated the grounds of arrest. Thus, it is seen that there is sufficient compliance of Section 47 and 48 of BNSS. More so, the petitioner has filed his bail application before the learned trial court as well as before this court, and thus the very purpose of service of notice under Section 47 and 48 BNSS is seen to be served to it. My lord, the purpose of 47 and 48 is that they understand that why they are arrested, so that they can avail bail. So, my lord, in this case also, we have given the intimation through telephone, and the phone number is also written here very clearly. And the purpose is already served, my lord. The purpose is that they understood the grounds of arrest, so that they can avail bail without delay.
May I, my lord?
Just a minute. Please come to paragraph 3.
Paragraph 3 of my bail application.
Petition, yes. We are failing to understand that part.
That the petition
two
back to
dates.
state an FIR was lodged by such and such.
By such and
reserve-
such? No. Read the whole words.
That the
Petitioner
petitioner begs to state that on 21 an FIR was lodged by SI of police, namely H. Lalpenglua of Southal Bay, alleging inter alia that on 4 an information
Now,
was
just a
received from it.
minute. On 21/11 an FIR was lodged alleging that on 4/12/25
I think
something
the
happened.
date is mistakenly written.
Well, maybe because that para 3 statement is a statement from record, my lord. The record is at page number, that is the FIR which we have annexed. It is at page number, your lordship may kindly find the FIR at page number 12, 1-2. So this is the FIR, my lord. I have the honor to stay on 4/12/2025 while I was on, yes, it is 4/12 even in the FIR itself, the first line of the FIR.
This is a part of your this thing, CD.
Yes, my lord, it's a part of the CD. I have been sent just this morning. So I have got it printed from my phone.
Yes, Mr.
Yes, my
Biswas.
lord. Yes, my lord will kindly come to page number, this page 15, 1-5. Now this they say is a compliance of section 48 of the BNSS. To substantiate, for compliance of 48, this is the document they are having. Number 1, my lord, with my limited knowledge, I fail to understand what this document is, because it is addressed to none. It is addressed to none, number 1. Number 2, even if I take this document to be in a language understood by the family members, even then this is not a compliance, because here the onus is given on the accused. The onus is upon the prosecution to intimate. I take a clear stand that this was never received by me. Now the Supreme Court says in Mihir Ranjan, your lordship is well aware, that once there is a non-compliance, then the burden is on the prosecution to prove his compliance. I can give the exact citation, exact para number. Now if your lordship kindly comes to my bail petition, para number 6, the precise paragraph of those judgment I have quoted where it says that the precise grounds of arrest has to be communicated. My lord, there are 2 things which your lordship is well aware. One is intimation of arrest and the other is ground of arrest. Now this communication, my lord, which I am denying, because they are saying that I have communicated. They are not saying in their this. Now, my lord, they have neither sent any notice to the nearest police station which they could have done. No WhatsApp communication whatsoever was ever made which they could have done and which could have been some remote compliance. I mean, had those been there, my limb of argument would have been different. But here there is nothing of this sort. Supreme Court has clearly said, my lord, your lordship is aware, even in Vihan Kumar, Justice N. Singh in the last paragraph has said that the duty is not only to inform the ground of arrest to the detainee, but also to his family members so that they can take to legal recourse soon. That's the clear mandate. Now, my lord, kindly come to page 6, para 6 of my bail petition. The precise paragraphs which I have quoted, my lord, the precise paragraphs I have quoted. The petitioner's back twist, arresting authorities have violated the provisions of 48 of the BNSS, which resulted in violation of petitioner's fundamental rights. Okay, I'll skip this. I'll come to the Supreme Court's observation. Para 3 of the judgment of Vihan Kumar. My lord may skip the initial observations and straight away come to right-hand side corner which states with hence. These are quote unquote from Vihan Kumar. Hence the requirement of communicating the ground of arrest. I take a pause here, my lord. The grounds of arrest in writing is not only to the arrested person but also to the friends, relatives or such other person as may be disclosed or nominated by the arrested person so as to make the mandate of 22(1) of the Constitution meaningful and effective, failing which such arrest may be rendered illegal. Reiterating the same, in Kesava Upendra Reddy, para 18H, quote, the grounds of arrest should not only be provided to the arrestee but also to his family members and relatives so that necessary arrangements are made to secure the release of the person arrested. My lord, where on earth is a single liner anywhere which shows that the grounds of arrest has been communicated merely because on a returnable date by means of a submission by an additional a public prosecutor? The document which your lordship has been shown is section 47. I have not even argued on section 47. Then your lordship may come to para number 7, what Mihir Ranjan Shah says, para 44. Mere communication of the grounds in a language not understood by the person arrested does not fulfill the constitutional mandate under Article 22 of the Constitution of India. The failure to supply such grounds in a language understood by the arrestee renders the constitutional safeguards illusory and infringes the personal liberty of the person as guaranteed under Article 21 and 22 of the Constitution.
Since you have not argued on 47,
yes,
this particular paragraph we can skip because this is with regard to notice under section 47.
Absolutely, my lord.
Yes, we'll skip this paragraph.
Yes. Yes, these are observations are on 47, 48 both. Now, my lord will kindly appreciate one thing. My lord will kindly see this notice which they say because 48 notice is a notice to the relatives and family members. So 48 notice should invariably contain the signature of the family members. Now I can understand they are from a different place. Send it to their WhatsApp communication. Your lordship has come across n number of cases where through WhatsApp communication it has been intimated and there is a mil gaya, okay, received, those sort of counter messages. Then it proves that okay, fine, there has been substantial compliance. But a 48, I will not even call it a 48 notice. This is a write-up by an IO, countersigned by the accused who is in custody, written in a Mizo language, and an oral submission that it has been communicated. What has been communicated, my lord? How do I know?
You were arrested on 14th of December 2025.
My lord.
Did you move any other bail application in any court?
To my instruction, no, my lord, because
prior to this, nothing has happened.
We are on custody on 126 days we are in custody. Now after 4 months, my lord, probably after 4 months, at some point of time, definitely I'll come to know. But the mandate is immediately. Immediately can be construed as 12 days, 10 days, but immediately cannot be 4 months and 5 days. There is a division bench judgment of Justice Michael Jorantham and my lord, I forgot the other brother judge, the other learned judge, which were somewhere around 1 month or 2 months delay in communicating was held to be non-compliance. These are, my lord, settled law, my lord. This page 15 by no stretch can be a compliance of the mandate of 48. By no stretch. On an oral submission. If I may read this Kesava Reddy's para 18 subpara G. When an arrestee pleads before a court that the grounds of arrest were not communicated, the burden to prove the compliance of Article 22(1) is on the police authorities.
Okay. Anything else? Anything more, sir?
Well, these are, and I did not, because these are settled law, my lord. There are single judge judgments, my lord. There are different single judge judgments which are there, my lord. Even your lordship has passed also a lot of orders. There are single, but I thought your lordship is aware because the genesis are this Kesava Reddy and Rehan Kumar and Article 22 from where all it flows, my lord. It is in a given facts, what had happened in that case, my lord, how it was communicated, maybe immediately, maybe they filed some bail application within 1 or 2 days, therefore it was construed that probably they have knowledge. My lord, on those facts, my lord, I cannot argue. I am disarmed with the facts of those cases. But on a point of law, this is the law, my lord, which I have, to whatever little I understand, this is the law.
Okay. You would like us to go through the, you have the case diary with you.
I don't have, my lord, the case diary.
You would like us to go call for the case diary and go through it, or would you like us to decide on this point of law on this bail petition?
My lord, it is, I leave it up to your lordship, my lord.
See,
Because
this had come up day before yesterday, is it not?
it came up on Monday.
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 We did not call for the case diary
We did
because
not.
the only point argued was section 48 and section 47, right?
My lord, my lord.
Now, if those are the only grounds, we would not call for the CD. We'll decide on your arguments and the documents produced by the learned PT. And
Mala.
if you so desire that we should go through the case diary, then we shall have to call for it. The choice is yours. Because we
If
record
you're-
in the order that since only section 48 was argued, and the learned PP has produced the whatever documents she has.
47 notice probably.
47 notice and whatever it is. So we have proceeded on that manner. Or if you want that, no, we should call for the CD, have a look through the CD for ourselves.
That whether there is a compliance of 48 or not in that.
Then we'll have to fix it on 20th, 20, allowing her to produce the CD, is it not?
All right, ma'am.
Or
I
we can
do
have it
that.
decided if you say so. Because we
Now,
don't
I'll-
want that to be another ground saying that the court did not even call for the CD. It has to be with your consent that yes, it can be decided without the CD, that will decide only the part of 48.
My lord, if I understand, my lord, what is falling from your lordship. If your lordship is desirous to see the CD in the to see whether there is any further compliance of 48, in that event your lordship may call for the CD. But my lord, to my understanding, my lord, this 47 notice has got nothing to do with 48 compliance. These are two separate provisions, two separate set of.
We will call for the CD on the 20th, but prima facie we are just indicating that the notice under 47 which has been served and the contents of the 48 notice coupled with the order dated 33/2026 in 8 of 2026, bail application number 8 of 2026.
My lord, if I'm just, my lord, is it by Justice Mitali Thakuria, my lord, that order? My lord, I'll address on that case. I got which is that case. Because there is one judgment, I know I can flood this court with 100 judgments which does not confront with this judgment.
So given those circumstances, we'll list it on the 20th of April. calling for the
20.
CD to allowing the learned PP to call for to present the CD before the court.
All right, my lord.
Absolutely, my lord. My lord, this will give me an opportunity to come up with more single judge bench judgments, which categorically says no aberration when it comes to constitutional
It
mandate.
would also afford you the opportunity to contest the judgment given by the learned PP.
Absolutely, absolutely. I got
Okay,
that
heard
judgment.
Mr.
Yes.
S.C. Biswas, learned counsel appearing for the petitioner, also heard
My lord, M. Biswas, not S.C. Biswas.
M. Biswas. Apologies.
My lord, can it come up on 21st?
21st.
Tuesday.
Also heard Ms. So-and-so, learned PP appearing in the matter. Call for the case diary. List again on the 21st of April 2026.
21st would be Friday, my lord?
Would be a
Tuesday.
Which day?
Tuesday.
Yes.
Okay, okay.
Item
Or you want it
27.
on 24th? You want it on a Friday?
My lord, for me, Monday is convenient so that I can come because I will
think,
physically come for this.
I think the learned PP has some inconvenience.
It's my lord, fine, my lord, on 20 cents, subject to the convenience of the learned public prosecutor, my lord. I'll come on 20 on Tuesday, my lord.
Tuesday, 21st.
All right.
When the entire state is busy in polling stations, I'm on VC.
Think about us. We are not even on VC.
I was about to say that.
Item 27.
Yes?
Your Lordship, may I please, Your Lordship.
Please.
Your Lordship, this is a bail application filed by the petitioner under Section 483 of BNSS, read with 37 of NDPS Act, for the alleged recovery of 102 soap cases of heroin. Your Lordship. Your Lordship, my grounds is that no contraband was recovered from the physical possession of the petitioner, and it was recovered from a room. From room, Kiangte homestay.
Okay.
Yes, Kiangte homestay. And no written grounds of arrest was furnished to the accused petitioner.
No written grounds of arrest.
Yes, my lord.
You were inside the room when you were arrested?
Azol.
Huh?
Azol.
Were you inside the room when the material was recovered?
My lord. Yes, inside the room.
Okay.
And there is it results that your lordship, Article 22.
Just a minute.
Yes.
Okay. Yes, madam, 21st is a holiday. Elections.
Oh,
So when 22nd?
22nd is fine.
Yes. Yes, you were saying?
Yes, it results the violation of Article 22(1) of the Constitution of India, your lordship.
You were not given at all.
Yes, my
Yes,
lord. Yes, my lord. Your lordship. And
Yes, madam. Do you have any instructions on that?
No, my lord. I've already taken instructions. My lord. The arrest was made in 2023, long before the judgment were pronounced, the Vihan Kumar and the others. So, my lord, the case of Vihan Kumar and all, it will not apply in this case.
No, the case of, it would not be a case of Vihan Kumar. It will be a case where a person who is arrested is not furnished with an arrest memo, which is signed by independent witnesses certifying his arrest. Vihan Kumar, Mihir Rajesh Shah, these all would be 47-48. We are not on 47-48. We are on the arrest memo part here.
Arrest memo, my lord, I think it will be served.
That is, he is saying he was not served an arrest memo. That is
yes,
what you
my
are saying,
lord.
sir?
Yes, my lord.
Yes, he's saying that.
And also in this regard, my lord, may I place a judgment in this
First, let us find out whether the memo was served or not. Once it is
my
not
lord.
served, you may place
My
the
lord,
judgment.
page 25 is the seizure and arrest memo.
Page?
25.
Do hereby seize the below noted articles. Is it not?
Yes, my lord.
It is only the articles. And in a drug case is then witnesses, arrested person is Simpson. Yes, sir. What do you say about this? Page
My lord, the
25.
seized articles is written down here, my lord, in the right-hand side.
Yes, my lord. This is-
1216, 1,216 grams of suspected heroin.
Yes.
Page 25.
Yes, my
Yes,
lord. This is a seizure memo.
And
And this is not a grounds of arrest, which is mandated by Vihan Kumar. And
Vihan
so, in
Kumar
this
is not
regard, Your
charged
Lordship,
with this
in this regard, I want to submit this judgment. May I place a judgment on record, Your Lordship?
yes.
Your Lordship,
Yes.
may I read out a relevant portion?
Yes.
On page 4. Now, the law of prospective and retrospective operation is absolutely clear. Whereas the law made by the legislature is always prospective in nature, unless it has been specifically stated in the statute itself about its retrospective operation. The reserve is true for the law which is laid down by a constitutional court, or law as it is interpreted by the court. The judgment of the court will always be retrospective in nature, unless the judgment itself specifically states that the judgment will.
It is not about the application of law or the interpretation of law.
Yes.
The directions given.
Yes, my lord.
The
But-
directions given is henceforth you will do it like this. That was wrong. Henceforth you will do it like this. So the applicability of the illegality will be from the period earlier. But the requirement to do it in a particular mode is henceforth. We want this pen to be kept in this. Right?
Yes, my lord.
No one kept it, everybody kept it here.
Yes.
We say henceforth it will be kept here.
Yes,
So
my lord.
whatever was kept earlier here cannot be declared to be illegal because it is henceforth. That is where the henceforth and the retrospectivity comes in.
Yes, my
Not on the interpretation of law, on the directions given, what is to be done, how it is to be done. That is prospective. Number one. Number two, at page 25, not only are you given the information that you are being arrested, it has been signed by independent witnesses and you have been informed that so-and-so, cannot the seized pink color, so-and-so, used for concealment of the seized suspected heroin. She herself opened the pouch. Seized suspected heroin is marked as so-and-so, kept in a black polythene. How much further grounds do you need? What further grounds need to be given to you?
Your Lordship, it was a settled law because in a case of DK Basu, it was already said about Article 22. This is the rights of the accused petitioner.
The
This is
arrest
the rights of, yes.
Arrest memo signed by independent witnesses to be
Yes,
given.
my lord.
This is given.
But it does not indicate that there is no mentioning of they have the right to consult the advocates, and also they had the right to consult the legal practitioner, and also did not write in here. It is not specifically not mentioning about the grounds of arrest, which is already recently mandated in a case of Supreme Court judgment. Also, Your Lordship,
The arrest memo should say that, should also contain a term that he has a right to engage a counsel. Are you saying that?
yes, my Lord.
Where is that? From where do we find that?
It was mentioned in Article 22.1, Your Lordship.
Huh?
Article 22.1.
No, Article 22(1), every man is supposed to know the law. Article 22(1), everyone.
It was also mentioned in they can have the right to consult a legal practitioner.
They have.
Yes.
Is it?
It was already write down in Article 22.1 of the Constitution of India, Your Lordship. This is already a settled law before the judgment of the Supreme Court recently made.
Do you say that they were not allowed to be represented by a counsel?
Yes, my Lord.
They were allowed to. What stopped them? How many days in custody?
2 years and 7 months, Your Lordship.
What is the stage of?
It's a defense evidence, Your Lordship.
Defense?
And, Your Lordship, may I submit my second grounds? And the co-accused, Lam Min Thang Sison, was already released by this Honorable Court, Your Lordship.
On what ground? Do you have the judgment? The order?
Yes, and that's ground.
Do you have the order?
Yes, in Annexure 6, in page 56, Your Lordship.
56.
Yes. Your Lordship, in this particular case, the true accused person, there is a true accused person which play a similar roles and similar position.
They were arrested together.
Yes, my Lord.
Yes, madam, what do you say?
My lord, though the co-accused has already been released in bail, but my lord, in criminal matters, has to be, every bail application has to be seen independently. So my lord, I don't think this case will cover the other case also.
No, since it is the same arrest memo, seizure list and arrest memo remains the same.
It's the same.
The documents remain the same. And it is only on the basis of the documents that this court had granted the bail to one of the persons arrested under the same document.
Yes.
Can we deny to the other? Page 57. We'll take it up after 2-3 minutes. You go through it. Page 57, whether the same things are there.
I've seen that, my lord. Yes.
Then from what we have seen is that the same arrest memo and
My lord, yes.
see at paragraph 4, page 58, refer to the seizure cum arrest
Yes,
memo.
that's what, my lord.
Is it
But,
not? This court has
my
already
lord,
considered.
Let my submissions be recorded because I have a separate submission other than the previous bail application. So if it can be recorded in the.
So what is your separate submission?
My lord, that the case of this Vihan Kumar and Prabir Pukra, it does not apply, it cannot apply in this case. And the procedures has been followed in this case.
Why does Prabir Purkasta not apply? 2023. Arrest is of 2023, no?
23, yes, my lord, but it's after, it's in 13/8 August,
2023.
yes. The arrest was made on August 2023. And my lord, I have also produced one citation. I have given a 2020 3 SCC, where it states that in any criminal case, it should have a prospective declaration of law.
Okay. Heard Mr. Swensolan and counsel paying for the petition. I also heard the learned PP. This application under section 483 of the BNSS has been preferred, praying for grant of bail to the petitioner, namely so and so, in connection with, you'll find it at page 1, huh? Connection with criminal TR excise number so and so. What do you? Criminal TR number so and so. Full stop. The petitioner was arrested on. When were you arrested, sir?
13/8, Your Lordship.
13/8/2023.
Yes, my lord.
13/8/2023. Full stop. The General Counsel for the petitioner has submitted that in the absence of any notice under section 50 or oblique 50A of the CRPC within bracket as it existed then, comma, the petitioner was never furnished the grounds of arrest, and further his family, friends or relatives had also not been informed regarding his arrest. Her or his?
Yes.
His.
No, my lord, her.
Huh?
Her.
Her, no?
Yes. Oh.
Page 17 appears to be a her, ma'am. On page 17, it appears to be a lady. Good stuff. The General Counsel for the petitioner has submitted that in view of the settled position in law that detention after a illegal arrest would be unconstitutional, comma, he submits that the petitioner be granted the privilege of bail during the remainder of the trial proceedings, full stop. The General Counsel for the petitioner has submitted that the trial is now at the stage of evidence by defense, and the petitioner has fully cooperated with the trial, full stop. The General Counsel for the petitioner has further submitted that there were 2 accused in the case, and the other accused has already been granted bail by the order dated 5/3/2026, passed in bail application number 5 of 2026 by this court on the ground that the arrest and detention of the petitioner suffered from violation of constitutional mandates. He has accordingly prayed that the prayer for granting bail to the petitioner with such conditions as we deem necessary be allowed by this court. Miss Pombel, the learned APP appearing for the state of Mizoram, has submitted that the recovery of the there are prima facie chances of conviction of the petitioner in the trial, and therefore the prayer for bail does not require a consideration at this stage. Full stop. The learned PP has also drawn attention of this court to the seizure and arrest memo dated. What is the date of this? 13/8/2023, to submit that the not only was the arrest of the petitioner witnessed and attested by independent witness, comma, the seizure and arrest memo also contained the grounds of arrest of the petitioner. The learned PP has submitted that the judgments in the case of Prabir Purkayastha versus the state within bracket NCT of Delhi, reported in 2024 Supreme within bracket online within bracket SC 3630 would not be applicable to the present case, since the said judgment cannot be said to have a retrospective effect. What was your other submission? This is that Prabir Purkayastha will not be applicable.
Yes, my lord.
And the other one?
My lord, even though the co-accused has been granted bail, the bail application of the present appellant has to be considered independently. And since the case also is at the end stage, my lord, there is a conviction chance.
That I have said in the beginning.
All right, ma'am. And the other is, my lord, I've produced one citation regarding
This
the,
one.
yes.
The learned counsel, the learned PP has submitted that in view of the judgment of the apex court in Varinder Kumar versus State of Himachal Pradesh, reported in 2023 SCC 321.
At para 17 minutes.
Where does it say so?
Para 17 onwards, my lord. Para 17.
17. To impress upon this court that judgments in criminal matters deserve to be given a prospective effect.
Yes.
And therefore the judgment of the directions laid down in Prabir Purkayastha would not be applicable to the present case. Stop. The learned counsel for the petitioner has placed reliance on the judgment rendered in Kanishk Sinha and another versus State of West Bengal and another, reported in 2025 Supreme within bracket SC 411, to submit that unless stated otherwise, judgments of the courts of record would be retrospective. We have heard the learned counsel for the parties. There is no assertion made on behalf of the state and made on behalf of the state that the arrest memo, as required under law, had been served upon the petitioner at any point of time subsequent to her arrest. Stop. Having regard to the provisions of the Article 22 within bracket 1 of the Constitution of India, this court is of the opinion that when the mandate, when the petitioner had not been served with the mandatory arrest memo, comma, the further detention of the petitioner had been rendered unconstitutional. A perusal of the seizure and arrest memo does not reveal that the grounds of arrest were specifically indicated. This court also notices that a co-accused has been granted bail. No, don't say a co-accused, say the only other co-accused in the matter has been granted bail by the order dated 5/3/2026. It may be correct that without commenting on the submissions made at the bar regarding the prospectivity or retrospectivity, that prospective or retrospective application of probable Purcaster versus state, this court is of the opinion that when the co-accused has been granted a bail in the similar offense and on the same offense and who was also facing the same trial, and in view of the absence of the notices under section 50 and 50A of the CRPC as it existed then, and in the absence of a formal arrest memo, the further detention of the petitioner would not be in accordance with law. Accordingly, this court directs that the petitioner shall be released on bail in connection with, what is this case number?
SR number 397 of 2023, Your Lordship. SR number 397 of 2023.
Criminal SR number 397 of
Criminal trial number 226 of 2023.
Criminal SR number 397 of 2023. Reference criminal trial within bracket excise number 226 of 2023, pending in the court of
NDPS Act Aizol.
NDPS.
NDPS
Special court. NDPS Act.
Yes, my lord.
Aizol, Mizoram, on furnishing a bond of rupees 50,000 with one surety of the like amount, subject to the satisfaction of the court, provided that one of the bailers shall be a government servant, Government servant, serving either with the central or the state government, The petitioner has declared herself to be a resident of a locality which is beyond the territorial jurisdiction of the trial court. In such circumstances,
Your Lordship, may I? Because the petitioner is Manipur, Your Lordship. So it may be difficult to a bailer
to appear.
No, Your Lordship, for government advocate. No, my lord, government
servant is necessary, sir, because she is from outside the state. Had she be from within the state, it would have been different matter. We are not saying that you require a government servant from Manipur.
Yes, my lord.
A government servant serving here will do. A government servant from Manipur coming here and giving the bail would do.
Okay.
Because in earlier cases also, when the parties are not from the state where the trial is being held, strict conditions have to come in. Otherwise, the chances of trying to trace back that person becomes very difficult. There is one judgment that's earlier also I given, Pamidi Anand I gave you, from that one. Guwahati also had given those conditions outside the district.
Supply.
Item 28.
Lordship, this is the MAC appeal. Then I'm appearing on behalf of Mr. Lalrem Tluanga, counsel for the appellant, Your Lordship. And Lordship, this may be taken up after ensuring the vacation. Mr. Lalrem Tluanga is not able to come today due to personal
What is the ground of
difficulty.
appeal? What is the ground of your appeal?
Their main grounds of appeal from the insurance company is that that deceased was the bachelor, and it was not deducted 50% as per the Salaverma. It was deducted 1/4 on the ground that they are the large family members in the deceased family. So that was the main ground. And 50% was already deposited to the registry of this honorable court, and it was already disbursed.
We'll admit it and fix it for here.
Yes, yes, Lordship, may be admitted.
What about the?
They are on leg, Lordship.
Okay. Mr. Swenson and counsel appearing for the appellants. The appeal is admitted. List in the hearing column in the week commencing when 4th of May.
Oh, Lordship, last month of April, Lordship.
Last week of April.
Last week of April.
27th of April.
Item 29.
My Lord, in these matters, 29, 30, 31, I am representing the appellant in RFA. It's similar matter as yesterday, my Lord. Now, in our RFA,
yes,
there are applicants who sought for disbursement of 50% of the amount, which will be answered by the learned government advocate, as the department is planning to engage her, I believe.
May it please Your Lordship, I'm appearing on behalf of the state respondents. Your Lordship, in this regard, the Vakalatnama has been executed yesterday for all the 5 IAs filed in the 5 RFAs. Your Lordship, it was listed. The previous 2 RFAs of yesterday are fixed on the 23rd.
Of April.
Yes, Your Lordship. So similarly, if these matters may also be listed on the 23rd, because Your Lordship, I am yet to receive the IA copies as well.
Heard Ms. Swenson and counsel appearing for the applicants. Mr. Swenson appears for the. You don't appear in this case.
I'm for the appellant.
No, you are not appearing in this case, are you?
I'm not appearing in the IA.
Then you
I'm
don't
appearing
appear in
the
this
main.
case. Then you don't appear in this case. Ms. Swenson appears for the state respondents, full stop. The learned counsel for the respondent has submitted that she is yet to receive copies of the IA. The counsel for the applicants shall ensure service of extra copies during the course of the day. Full stop. Place this matter again on 23rd of April 2026, allowing the state respondents to file their response to the interlocutory application.
Much obliged, Your Lordship.
Item 30.
Similar prayer for item number 30 and 31 as well, Your Lordship.
Yes. 30 and 31 same.
Yes, Your Lordship.
Hearing list, item 1.
I think item number 1 was fixed at 2 yesterday.
Item 3.
Is the green pass matter, no? Item 1? At 2. इसको बुलाओ.
Basic, Your Lordship.
Yes.
I'm waiting for item number 15, since the PP is...
Item 15 of the hearing list.
Yes.
Okay.
Since the PP is currently not available, it may be taken up after item number 1.
After item number 1, okay. Today itself.
Today itself.
We'll check.
Yes, in the afternoon.
Item 15. Yes, Mr. Chetia?
Lordship, in respect of item number 14, my lord, it is fixed for today, Lordship.
Item 14 of?
Part
Yes.
2, my lord.
Part 2, item 14. I mean 14. Yes, 14. Your Lordship, if it can be taken up after
Now
item
also?
number 1 in the afternoon.
Why not now? Mr. Chetia, we can take it up now.
Lordship,
Huh?
Lordship.
Yes, if you're ready.
I have, since the PP is not here and since I have some small meeting
Okay.
that begins very shortly, it will be over in 20 minutes only.
15?
14, I mean.
Okay. We have a fixed matter at 2 o'clock.
Lordship.
After that, we'll take up your matter.
My lord, my lord.
Okay.
Yes. Thank you. Obliged, Your Lordship.
I'm okay.
Hearing list, item 1.
Yes, sir.
Lordship, ours is a comparatively simple case. This is a matter regarding premature retirement of the petitioner. The petitioner is a tutor in the nursing department under refunds, and he has been appointed as such, and has been serving in that capacity till he was released. On alleged superannuation pension, on 30, 34, 20, 22, 24, 34, 20, 24, as per office order at page 36, page 76, Your Lordship. This office order dated 24th May 2024 indicates that this is the information, this for information to all concerned that the following staff of refunds was retired with effect from date mentioned below. Dr. Vanal Ruata, tutor, and his date of retirement has been shown as 30/4/2024. Reason for retirement, superannuation. Prior to this, Your Lordship, there is an office order which is at page 71. May I take Lordship to page 71, which office order dated 6 March 2024. May I read, Lordship?
Yes.
In continuation of this office order of even number dated so and so, and in pursuance to the approval of Honorable HFM in his capacity of President of Board of Governor, Refunds, Aizol, and as ratified by the Board of Governor in its 11th meeting held on 12/12/2023, it is hereby notified to all concerned that tutors of Refunds in nursing department have been included as member of teaching faculty, in addition to the post already identified in terms of provision 2.2 subclause 5 of the bylaws of refunds, and the age of superannuation has been enhanced to 65 years, which will be applicable to those having MSc in nursing, subject to the condition that these nurses would continue to function as faculty after the age of 60 years.
What is the age till which you want to serve?
Till 62, Your Lordship.
This is for 65.
This is for 65, but this is applicable in respect of MSc nursing. If he is MSc nursing, then he will have to continue, if he desires, till the age of 65. Otherwise, all other staff, teaching staff, are supposed to retire at the age of 62. If I take a Lordship to the relevant rules, tenure of service as per Memorandum of Association at page 38. Page 38, Your Lordship. Rule 22.
Page 30?
Page 38.
Government of India, okay.
Wherein it is provided, Your Lordship, that save as otherwise prescribed, all employees of the institute, after successful completion of their probationary period, will be offered continuous appointment up to the date of superannuation, which shall be the date of attaining
the age as determined by the government of India from time to time. And Lordship, as per page 43, the bylaws of the Regional Institute of Paramedical and
Page?
Nursing Science, page 43, Annexure 2.
Uh-huh.
Under definitions,
Yes.
2 subclause 5, member of the teaching faculty means professors, readers, assistant professors, selection grade lecturers, senior grade lecturers, and lecturer. So this definition has been widened by the office order which I have just read out, Lordship, which indicates that the retirement age in respect of, in respect of the tutor has been included as a member of the teaching faculty. So here, Lordship, there is minutes of the 33rd Executive Council meeting at page 69. As per Annexure 8, starting from 68.
So you were retired
69.
at the age of 60.
Yes, Lordship.
Yes, sir. How do you do it?
My lord, the only
Well,
point
we understand your condition that if it's a medical, it's a faculty or something, then it would be 60, 65.
Yes.
But since he is not in the faculty or teaching unit,
Right.
then he would be 60.
60.
Why?
If it is non-faculty member, my lord.
Then it is?
Tutor, the present
No,
post.
we take away the term tutor.
Yes.
If we use the term tutor, he is faculty.
Yes.
Plain simple.
Since the time when it was approved as a teaching faculty member, earlier it was non-teaching faculty, the post.
So if he is non-teaching, what is he?
Non-teaching, it would be 60 years.
No, what? Where do we find that?
There's your lordship, now there is a definition of teaching faculty as per the rules. It is at page 43.
So everybody else is non-teaching.
Yes, page
Anybody
43.
who does not fall in the definition, page
43 of the writ petition.
Now, just tell us this. Anybody who does not fall in teaching
Yes.
or faculty
Yes.
falls in?
Falls at the age, superannuation age is 60.
Where do we find it?
This is your lordship as per the...
You have to remember that he is a MBBS doctor.
Right.
Serving in the institute. Maybe in an administrative post.
Yes.
Then what happens?
But it is...
Let us read page 69.
Response is guided by these bylaws and
Let
the
us
other...
read page 69.
69. All right, my lord. Yes, your lordship.
Noted by the committee, item 2. Regarding superannuation age of teaching faculty. Chairman explained that Cabinet has approved enhancement of superannuation age of all medical doctors of central government with up to 65 years with administrative functional responsibility up to 62 years.
Yes.
Beyond 62 years, they shall perform only clinical duties.
Yes.
So now, here you are saying the teaching faculty.
Yes.
Chairman explained that the enhancement of superannuation age of medical doctors of all central government hospitals
Yes.
is up to 65. Till 62, they will do administrative duties. After 62, they will do only clinical duties.
Yes.
Now, this man does not have any clinical duties. Perhaps.
Yes.
We do not know. But he will be there till 62. How do you say?
But your lordship, the RIPANS is the institute, autonomous body,
Ah.
and it is governed by its own bylaws and other rules, which are framed.
So your bylaws says that whatever is applicable to
Applicable to central government.
will be applicable to you.
But
Central
if-
government, all doctors are 62.
But it is subject to the approval of the RIPANS governing body.
Wait. Show us. Tenure of service.
Yes.
Where does it require an approval?
Tenure of service, all employees of the institute after successful so will be offered continuous appointment, which shall be the date of attaining the age as determined by the Government of India from time to time.
So where do you need that approval?
However, your
65 we understand.
yes,
65 we may understand that he does not have an MSc, but you also have to take into account that he has got an MBBS degree.
that is true.
Okay, he is not a nurse, he is a doctor.
Yes, that is true, my lord. This is also admitted by the petitioner. And may I take your
he's a
lordship to page 79?
He is a doctor. We do not have any qualm on that.
Yes.
But if it is a doctor,
The strength of the petitioner is that, my lord, the superannuation age for a non-teaching faculty is 60 years. It is also admitted in their petition also. And if we look at page 81, this is the type copy. Yes, 79 is the original copy, my lord, of the writ petition. I'm referring to writ petition. And retype copy will be more clear, my lord. 81. That the right column, my lord. Let me start from the 22nd EC meeting held on so-and-so, decided enhancement of superannuation age of teaching faculty staff up to 62 years on par with the CHS. The superannuation age of all other staff shall remain at 60 years. So now the only issue is that prior to the approval of enhancement of this is at page.
how many doctors are there in the RIPANS?
RIPANS, not many, but my lord, I'm sorry to say that I could not.
Because see, all other faculty.
Yes.
Now, if the central government says that for doctors it is everywhere 62, your memorandum of association says we will follow central government.
Yes.
Can doctors be left out?
But it has to be subject to the approval of the
No, the
governing body.
memorandum of association doesn't say so. And in your rules, does it, in your bylaws, does it anywhere say that yes, all this will require?
But it is what we follow, and this is also admitted by the present petitioner, my lord. If the only stand he is taken by him at present by filing writ petition is that after approval or inclusion of the tutor post as the teaching faculty, he is saying that I am entitled to superannuated at the age of 62 years.
How do you say 62, sir?
That is also that is
How
the
do you
stand
say
taken by
62?
him.
It has to be 65 or 60.
Yes, yes. Your Lordship, there are two things. In the prayer, we have said that where the petitioner shall not be reinstated to his service by allowing him to continue in his post as tutor in the nursing department under RIPANS with all service benefits with effect from 34/20/24 till he attains the age of superannuation, that is 62 years or 65 years as may be decided by the respondents in due course. And after hearing both parties, Your Lordship.
You have to tell us,
there are two
why you
things.
say 62.
There at page 81, there is 62, which has been approved by the EC. And this is supported by the EC meeting minutes at page 83, Your Lordship. 83 is not clear, it has been, true type copy is there. At the bottom of page 84, Your Lordship will see AOB 1 and 2. One is superannuation age of academic and administrative staff. The committee discussed the proposal and approved to enhance the superannuation age of teaching staff up to 62 years on par with CHS, Central Health Services. The superannuation of all other staff shall remain at 60 years. So, taking this as a basis, Lordship, at least the petitioner is entitled to be in service up to the age of 62 years. And as per decision of the central government, it is 65 years. And as the Lordship had rightly observed, as per the rules and regulations of the refunds, it has been stated that the tenure of service and the date of superannuation will be the date of attaining the age of age as determined by the government of India from time to time. In respect of CHS, doctors working under Central Health Services, they have been allowed to continue till 65. So far as refunds is concerned, which is a central, the central government autonomous body. And this 65 years has not been implemented so far as the employees of the refunds are concerned. So my humble prayer is that let the petitioner continue at least till the age of 62 years until it is fully and finally decided.
Is 13th of August 2018 applicable to you? Page 65.
65. This is also, my lord, this is subject to the approval by the, to be given by the governing.
Where is it said?
And
It
this
will
has
be-
been,
This has to be subject to approval.
regarding the tenure, it was not specifically mentioned that approval needed to be given. But in the recruitment, it was mentioned, my lord.
In the
Recruitment part, let me, my lord. Page 48, this is the recruitment rules. Six point two. It says that with the approval of the Executive Council.
in conformity with those prescribed for corresponding post
Yes.
by the central government.
So this is why what we are following, we have been following is that suppose there is one office memoranda or memoranda issued by the central government, that cannot be, in toto, it cannot be directly applicable to the employees of the refunds because it is an autonomous body. So that Executive Council has to approve it.
Then
So
what
that is,
happens to clause 22 of page 38?
page, my lord.
Page 38. Recruitment
Yes.
rules, you are saying this is recruitment rules. The age, the qualification and the experience.
Yes.
Etc. So we'll have to understand it to be those conditions which are required for recruitment.
Yes.
It has to be approved by the EC.
Yes.
What about the superannuation part?
Superannuation
Tenure.
part, there is no
Tenure is specifically at page 38.
yes
22.
specific mentioning of the approval of the EC. It is not written here.
Ah,
But
so-
still, what we have been what the petitioner has also admitted is that, my lord, the only issue
He says
raised by
that-
him is that
He says that once you have included the post of tutor
yes,
as faculty
yes,
from non-faculty,
yes,
I become faculty.
yes,
Now, if I have MSc in nursing, I will work till 65. Otherwise, like all faculty, I'll work.
no,
till
no, that is
62.
not his case, my lord. Now he is claiming only for superannuation age at the age of 62 only.
That is what I'm saying.
Yes,
He says that now that you have included the post of tutor
yes,
as faculty.
yes,
Now, if such a faculty has got MSc in nursing, he will work till 65. If someone does not have that MSc, being faculty, he will work till 62.
62, if his
So I
faculty.
will work till 62.
That is true. But now the only point is that this is the impugn order, Your Lordship. Let me take Your Lordship to page. This is the one. Mm. Your Lordship, page 75. Sorry. Your Lordship, page 71. If it is to be taken, if this has to be read conjunctively, Your Lordship.
Page 70?
Page 71, Annex 9.
Uh,
I'll read this, Your Lordship, once again. In continuation of this office order so and so, with the approval of Honorable HFM in capacity of so and as ratified by the Board of Governors in its 11th meeting held on 12/12/2023, it is hereby notified to all concerned that tutors of repunts in nursing department have been included as member of teaching faculty in addition to the post already identified in terms of provision 2, subclause 5 of bylaws of repunts, and the age of superannuation has been
now
enhanced to
we'll
65
just
years.
wait there for a minute.
Yes.
End word is
Yes.
what?
And
There are two parts of that sentence.
yes. And the age
One
of
is the former part,
former part
which
is addition
says
of
that tutors of nursing department have been included as member of teaching faculty.
yes.
So now that tutor word comes into that original faculty,
Right.
members of the faculty.
Correct. Right.
Second part is the age is being enhanced to 65
Yes.
for those persons who have got MSc in nursing.
Yes.
So there are two parts of the sentence. Second part does not apply to him.
If that is so, what your lordship is saying, and the claim may also be correct. Now we are reading this conjunctively, my lord. That is the
Conjunctively?
only thing. Means
You want to say that this tutors of repunts in nursing department has been included as member of teaching faculty
yes,
will only be applicable
Applicable
to those
MSc.
tutors who had MSc.
That is correct, my lord. This is the reason why repunts authorities interpreted in this way. This is the only reason why he was not allowed to superannuate at the 62 years.
Now kindly come to page 62.
Yes.
Number
My lord.
7, page
My lord.
62.
Yes, your lordship.
Tutor health worker is there.
Health worker is there.
That is where he had applied.
Yes.
Now it says it has to be an MBBS
Yes.
or
BSc nursing.
then where is the question of a tutor being there in the nursing section with MSc?
This is
See, those
my understanding,
persons-
my lord.
Those persons who had MSc
Yes.
were already members of the faculty. Is it not?
Yes.
Where is that? See, now kindly come to that page 62.
62, yes.
Advertisement number 1 of 1997 you find? The table below, group 1, 3700 to 5000.
Right.
Now come to 2. Lecturers, pathologist, microbiologist, radiologist, ophthalmologist, physician, anatomy, ops, and gynecologist. So and so. Is it not? On your right, you will find master degree in the field. So the moment there is a nursing qualified candidate with MSc, they will come here. They are already defined as tutors. So there were other tutors. They were tutors in the nursing department who had only BSc. Now they are included in faculty. And all those who have MSc, they will now get extended till 65. Otherwise, how do you explain the education qualification of a tutor and of a member of the faculty? The only difference is one comes in with a master degree, one comes in with a
MBBS.
bachelor's degree.
Yes.
MBBS is bachelor's degree. So is BSc in nursing. So bachelors will be tutors and MScs will be faculty. Then you take a decision that all tutors will now be faculty. But only those faculty which have got masters will be 65 years of age. So those without faculty will be, those without masters will be usual faculty, 62.
Yes, that is true, my lord. This if it has to be read,
I have this bad habit of arguing for the petitioners.
yes,
Yes.
if it has to be like to be read in two parts, this is the impugn office order.
Otherwise,
So it doesn't mention about 62 years. There is
they become members of the faculty. You have made them members of the faculty.
that is true.
And that members of the faculty, that 11th governing council meeting says, faculty members 62.
There is the issue, the only issue to my understanding, my lord, is regarding the interpretation. If we read continuously all this.
Therefore, we cannot read continuously because of the end.
Yes. That is
That breaks
that
it
is the only issue to my understanding, my lord.
That
Yes.
breaks it up.
Yes. So this
Otherwise,
is the simple
65 we are
issue.
not concerned. 65 we are not convinced at all.
So this office order, while it allows to extend the superannuation age, it doesn't mention that 62 years. Because 60 is also admitted by the present
Need not
petitioner.
be. Faculties are already 62.
Yes, if the teaching faculty, if it is included as the faculty member, then yes, that is true. It has to be 62 as per Ripan's rules, norms to be followed. But if we read continuously all the sentences of this office order, then 62 is silent and it goes directly to 65 years, but that has to be availed by only MSc nursing only.
65 only MSc.
MSc
There is
nursing.
no doubt on it.
Yes.
There is no doubt on it.
So this office order which approved the extension of the year, superannuation year, it doesn't mention 62. That is why if we read continuously the whole part as a whole, the whole sentence, then he is not MSc nursing, so he cannot avail. That is our only stand. my
He
lord.
cannot avail 65. We agree with you totally.
Yes.
65, he is not reaching 65 in the
Right.
institution. But who have been brought in as member of faculty by that very order? Who has been brought in? Persons who were serving but in non-faculty post.
Yes.
He is one person who was serving but in a non-faculty post. The moment he is brought into as a member of the faculty, he will enjoy everything that is being granted to a member of the faculty. But to maintain the classification of persons with higher qualification or those who came in as as members of the faculty itself, for those persons, the benefit of 65 years is being given because you are teaching, you are faculty part. And since you have only been accommodated as a member of the faculty, you will not get that benefit. That is how we are understanding it.
Yes.
Unless you convince us otherwise.
Yes. I got your lordship's point, my lord. So the only thing is the way to interpret this part.
Now, this approval of the Nimhans, 12, at page 71, you are talking of some 11th meeting on 12/12/2023.
Yes.
Do you have that
No.
that resolution as such?
We have in the next in our affidavit in opposition also, my lord.
But that data is not annexed.
Yes, it is not an ex.
So that resolution may help.
It is
Yes.
annexed here, not.
Huh?
It is annexed here.
Where is it?
Page 83, 84. 84 is a type copy.
Yeah.
No. This is dated. No, I need 12/12/2023.
3/1,
Page
2006.
83. That is no.
No, the
If you
pleadings-
come to page 71, sir.
Page 71.
Page 71.
Yes, 12.
The third line from the top starts with the word isol and as ratified by the Board of Governors in its 11th meeting held on 12/12/2003 or 2023.
Lordship, here, Annexure 1. However, the BOG, Board of Governors, in its meeting held on 12/12/2023, ratified enhancement of superannuation age of tutor to 65 years, applicable to those having MSc in nursing subject to condition that these nurses would continue to function as faculty after the age of. This is what is referred here at page 71.
No, page 71.
71 is the office order.
Which one did you, what were you reading just now, sir?
I'm just reading page 81.
81 I have, 81.
81.
81 I have read.
Yes. And here in page
No,
71,
they have simply
referred to the decision
No,
made by the
this
Board
was
of
given to
Governors.
you. Who is Miss Lalrin Kimi?
Lalrin Kimi is the niece of the petitioner who has applied for information under RTI. It has been given.
No, then sir, you will have that copy. Kindly see. If you have that RTI copy with you, what is the second annexure?
Second annexure is missing in my copy.
It is missing in my copy
Oh.
also. That was
The
necessary.
annexure 1
Do you
is
have the
there.
second copy, sir?
Second copy, it is not there.
If you see page 81 again, sir, you will find copy of the Executive Council meeting. A minute is enclosed as 1. And at the end, copy enclosed as annexure 2. So with the RTI, you are given 2 annexures. One of them is annexed here with.
Yes.
Give us
The
the other.
content, the content of that decision.
Give us the other one. If you give us the other one,
Yes.
if you give us the other one, which says, oh, other one we don't need.
It is at page.
No,
the
we don't
content
need it.
is at
Page 84.
84.
Oh no, we'll need that
No,
second
no.
copy. Yes.
This is the
Second one, annexure 2 is missing.
Annexure 2 will be necessary to see as to why they were
Yes.
brought in as member of faculty.
Yes.
what is stated here is exactly what is there in the office order at 6 March 2024 at page 71. It's the same content. This is not in the form of the executive meeting minute, but in the form of order based on the Board of Governors meeting minute.
Faculty is the teaching staff. Is it, sir?
Yes, faculty.
Faculty is the teaching
teaching
yes,
staff.
teaching.
And non-faculty is?
Non-teaching.
Non-teaching.
Yes.
Now, all these non-faculties have been made faculties.
This BOG meeting minute 12/12/2022 will be relevant. I should have produced my lord if
If
necessary.
it is there with the RTI, can you find out from your client?
Yes,
Yes.
I think it will be there. But
Because
since
it should be there.
it should be there.
Now we are here only tomorrow.
We can
Thereafter
produce
we are
it tomorrow, lots of.
If you can produce it tomorrow. Otherwise, it is settled.
Yes.
If 12/12/2023 gives another picture than what we
Yes.
are understanding, then it may require further consideration.
That is what.
Yes.
Otherwise, if it reflects what we are saying,
Yes.
then the matter is resolved.
Yes, it is a simple issue only. ma'am.
Then we can simply hold that having that since he was a member of the non-faculty staff and they have been termed to be faculties
Yes.
by a particular board of governors resolution, he becomes a member of the faculty. Applying 30/1/2006, the age of the faculty staff is 62 years.
That is what.
If that be so, then he was entitled to have served till 62 years.
Correct, my lord.
Since he was not allowed to serve, consequences will follow.
Yes. MSc qualification would not be necessary.
Necessary. Up to 62, MSc will not be necessary. Beyond 62, MSc is necessary.
But
May
this
I take a lot to again to page 81, just to indicate that the BOG, Board of Governors in its meeting held on 12/12/2023, ratified enhancement of superannuation age of tutor to 65 years. And this very content is highlighted here in the office order at page 71.
Yes.
So
What they have understood, yes, sir.
what I'm trying to say is that the production of that executive, committee BOG meeting minute may not be necessary. Even in the absence of that, I think
No, if
it is the same content.
if the BOG meeting had discussed that discussion part as to why non-faculties are being now made members of the faculty.
The reasoning.
If
The
that
reason behind.
reasoning supports your case, you would have a stronger order. And if it is said that just for the sake of nomenclature we are doing it, then the thought may be different.
Right. We'll produce it tomorrow.
Because if we try to dispose a matter, we try to do it in a manner which would not prolong litigation higher up. It should be clear on out here itself as to what can be the relief granted. Yes, that is. Otherwise, our mind is made up.
Yes.
Or if you have anything to change our mind, kindly say us. Tell us. If you
No,
have
my
got
lord,
anything.
if we look at page 81, the wording itself, this is the right column. It appears that this BOG meeting 12/12/2023 mentions about enhancement of superannuation age conditionally only in favor of MSc nursing who are tutors. But if otherwise, if it says otherwise, then I think it will be very clear.
But
that
65 he will not be entitled to. He was not taken in as a faculty member. He was never in the teaching line. Being an MBBS doctor, I don't know how he would have taught nurses.
But that
Since the Ripans itself has now deemed it fit to bring them on into the category of members of faculty. So they are no longer administrative people.
if the
So for
BOG
administration, what other categories you have? There was in the definition clause. Page
teaching
43.
faculty. Teaching faculty is at page 43, my lord.
Now see, the finance officer, administrative officer, these people, the director, these people would be 60 years.
Yes. As per the rules.
Huh?
Yes.
And say not only these, there may be other people also, the persons who are serving in the finance department as such. There's not only one finance officer, there'll be other finance officer also, of other assistant finance officers, clerks, LDAs. All of them would be 60.
60.
Once you become a member of the faculty, 62 confirmed. If you have got a master's degree, 65 confirmed.
But that BOG meeting 12/12/2023 is the only approval given by the BOG for inclusion of tutor posts as teaching faculty. But if that is conditional, BOG approval is conditional.
If it says that tutors
Only-
who have MSc
Exactly, my lord.
would be now members of the faculty,
Yes.
then his case goes.
Yes, there is what.
But if he says that all non-faculty posts would now be members of the faculty
62
and
is clear.
65 will be for MSc,
Yes.
then he is in.
Yes, 62 is clear. I have nothing to say in that.
Yes, we'll need 12. It all
As
hinges
clear
on
as a
12.
day.
Huh?
It is as clear as a day.
But then tomorrow we will not have the time to hear it as such. We'll only go through 12/12/2023 and find out if relief can be granted.
Yes, ma'am.
And we'll have to keep it CAV because tomorrow we may not have time to dictate the whole order.
Okay.
At the request of the Learned Council for the petitioner, list this matter again tomorrow, enabling the production of the resolution taken by the Board of Governors on 12/12/2023.
Yes.
Which was also supplied to the petitioner as a part of the information supplied under the Right to Information Act. Tomorrow,
Obliged.
Much obliged.
Item 14.
I don't think it's a part, it will come here only. No, whatever, but it will come before this court only. Do I have to say part? Not necessary. Yes, sir.
Lordship, I am appealing for respondent number 6 and 7.
Uh-huh.
I am appealing for respondent number 6 and 7 in
Yes,
this
yes,
court.
yes. Your affidavit is on record, I believe.
Lordship.
Ah, yes. 6 is there, affidavit and reply is there. Yes, sir.
My lord, this is somewhat very simple thing. The entire case turns on one illegality. That is, the police handed over the seized cash to the respondent number 6 and 7, while it is under the court's control, without the court's order.
No, I did not understand. Again, can you come again?
Yes. The fact is that a sum of rupees 103 lakh 97,500. It was seized on 22nd to 2024 and brought within the criminal case. The police investigated the matter and found no criminality. And while the petitioner then approached the learned Chief Judicial Magistrate Champai under section 451 and 457 CRPC. And while her application for release was still pending, in violation of the law, the police handed over the entire case to the Income Tax Department without any court order. So that is the brief facts of the case.
It was confiscated by the police, seized by the police?
It was initially seized by Assam Rifles on duty.
Okay.
From 3 Myanmar nationals.
And then it was...
And then it was, after that, the Assam Rifles handed over the seized cash to the police, Champai police. And the petitioner here is, herein is a grocery owner, small grocery owner, a wholesale store at Champai district, Zaukothar village. That is bordering Myanmar. So her business involved regular transaction with wholesalers in Mizoram and customers from nearby tribal areas, including persons residing across the Myanmar border. So she is a legitimate border, she is running a legitimate trade grocery store. And the cash in question is her business proceeds and lawful commercial transaction, not the proceeds of crime. So on 22nd to 2024, at part 3 of my petition, Second Assam Rifles Nalan, posted on Nalan, intercepted 3 persons riding two-wheeler, and they were found carrying...
3 persons on a two-wheeler?
Yes.
That itself is a crime, is it not? Yes.
My lord, they are coming from Myanmar, obviously. So, after that, on suspicion that they may be involved in some smuggling or other criminal activities, they were handed over to the Champai police. First, they were handed over to Nalan police beat post, and thereafter, they were handed over to Champai police. The Assam Rifles did not conduct any independent investigation here, and they merely handed over the matter to the police. And after that, as we can see from para 4 of my petition, these 3 persons were taken to Champai police station and formally arrested under section 1 CRPC. And the case seized under section 102 on suspicion that it could be the proceeds of some smuggling or other criminal activities. So the police seized it, and Champai Police Station GDE number 433/2024 dated 22nd to 2024 was registered for inquiry. So from the very beginning, the seizure was purely on suspicion and not based on any established facts or offenses. And thereafter, on 23 to 2024, the accused were produced before the Chief Judicial Magistrate Champai, and they were remanded to police custody. And during the interrogation, the three persons, the arrested persons, consistently stated that the money was meant to be delivered to the applicant. And since the police found no evidence of smuggling or other any criminal activities, on 24 to 2024, the IO prayed for their discharge, these three foreign nationals. And they were released as no incriminating circumstances was found against them. Here, the police investigation completely ruled out any criminal activity from the very beginning.
The money was not seized from the petitioner hearing.
No.
Then how does she say that she is the owner of that money?
My lord, on learning that her money has been seized by the police, she immediately approached the police claiming her ownership. And she even submitted cash memos, relevant cash memos. She is the wholesale dealer.
She submitted cash memos for 1 crore something.
Yes, the way she operated her business is that she's a wholesaler. She took grocery items from RL store, ISO, and sometimes on credit and sometimes on payment. So it was, that money was meant to be delivered to the applicant, and then it is to pay back her debt from RL store. So the applicant, on learning that, the petitioner, on learning that the money was seized, he immediately approached the police and claimed the money, and he even submitted cash memos, relevant cash memos, that she took goods from RL store on credit. So she produced documentary evidence supporting her legitimate business and origin of the money. And from the very beginning, she claimed and established her ownership of the seized cash. But since there is no immediate response from the police, she filed an application under section 451 and 457 CRPC before the CJM Champai, Chief Judicial Magistrate, in May 2024. The case was registered as Criminal Miscellaneous Application number 5 of 2024. First order on that CMA was passed on 10/5/2024, and CJM Champai directed OC Champai PS to state whether the seized cash was still required for investigation or not, and to report the status of investigation. So thereafter, while the CMA was still pending, the police, the Champai police, sent through emails, one to ED, Enforcement Directorate, and one to IT, Income Tax, without the consent or without any order of the court. The steps taken by the police was without any direction from the court. And on 29/5/2024, inventory of cash found and seized was prepared by this IT department. And on 30 5, 2024. The police handed over the seized cash to income tax. That is respondent number 6 and
Allowing
7.
that money to be released to you now without there being any proceedings regarding the ownership of that money or
Yes.
the proof that the money belongs to you. Can this court in criminal revision do it? We can only see what is the wrong in the order passed by the learned CJM at best. Learned CJM says that you could not produce enough documents to show that the money belonged to you.
My lord, we have submitted all the relevant documents to the court, CJM. And while it was pending, that CMA, Zima application, while it was pending, the police handed over the entire cash to the respondent 6 and 7.
They do not have the place to keep it. They have to find out what is wrong in this order is what you have to show us, sir. It may be your money. If it is your money, it would be required to be released to you. No doubt on that.
Yes.
But how does this court decide in a revision petition whether that money is yours or not? Because even if we allow this petition,
She duly
we will say
established.
that, you have to go before the authority or the CJM,
Yes,
show that it was legal money.
my lord, I will come to that point. So
You will be kept where you are.
I'll come to that point, my lord. Once the foundation is unlawful, everything that follows is unlawful. Then thereafter, on 5/7/2024, the CJM dismissed the application, mainly on grounds that the cash had been transferred to respondent number 6 and 7, income tax official. And seizure, and one of the reasoning given by the CJM is that the cash was seized during the enforcement of model code of conduct. But that is not true. So, my lord, without the court order, it was already handed over to the IT department. And after that, only after the police had handed over the seized cash to IT department, this CMA was rejected. Only on ground that it has been already transferred to income tax department and the seizure has been occurred during the enforcement of model code of conduct for the election of Lok Sabha. So the reality is that the facts is that model code of conduct was not enforced on that period 22 to 2024. That is the time of arrest. It came into force. The election was announced only on 16/3/2024. So the petitioner has no other option because the CJM has already dismissed her application.
So this money is now with the
IT department now.
The IT department, yes, what do you say, Mr. Chetia? Simply someone handing over you some money, how do you keep it with yourself?
Now, my lord, there was a separate proceeding initiated under the Income Tax Act, Lordship. I'll refer to only three, my lord, annexures, 3 pages of the petition, my lord. First, my lord, when the information was received on, my lord, 15/5, that is annexure 11, page 51. It was a letter from Superintendent of Police Champai to the Income Tax Department stating that some amount was recovered. Thereafter, my lord, in my affidavit, Lordship, affidavit in opposition filed by respondent number 6 and 7, your Lordship may see page 16 of my affidavit, Lordship. That is important, my lord.
Page?
Internal page 16, Lordship.
Okay.
So, part of annexure 1.
Warrant of authorization under subsection so and so. That is the
Lordship,
one.
Lordship. Under subsection 1 of section 132A of the Income Tax Act. So, separate proceeding was initiated under the Income Tax Act, Lordship. Here, my lord, the principal director of Income Tax, my lord, the investigation has authorized, my lord, additional joint director, deputy director, and income tax officer, my lord, to search and seize, my lord, from the office of the, my lord, the police, my lord. And accordingly, my lord, the search operation was conducted, my lord. And accordingly, the said amount was seized, my lord. That was page 30, my lord. The punch number was drawn, my lord. So, my lord, a separate proceeding was initiated under the Income Tax Act, my lord.
But then
under section-
the statement made in the observation made by the CJM that persons of the Mizo community are not.
My lord, that is a separate issue, lordship, and that is not a blanket, my lord, exemption, my lord. My lord, under the Income Tax Act, lordship, there are 50 kind of separate various exemptions, and my lord, under subsection 26, that is exemption granted to the, my lord, the community, my lord, of the state of Mizoram, subject to certain other conditions.
The income must be from the hills itself and all that, na?
Lordship. Three conditions has to be satisfied.
Territory.
Lordship, state of Mizoram, my lord. And in fact, my lord, under section 293 of the Income Tax Act, for a moment your lordship may see section 293 of the Income Tax Act. It is specific bar, my lord, for the courts, my lord, to, my lord, try any proceeding or, my lord, suit you. Section 293.
Kannela.
293.
Got it, lordship? 293 section. Bar of suits in civil courts. No suit shall be brought in any civil court to set aside or modify any proceedings taken or order made under this act, and no prosecution, suit or other proceeding shall lie against the government or any officer of the government for anything in good faith done and intended to be done under this act.
My lord, this is not a civil suit.
Eh?
This is not a civil suit.
He is saying this is not a civil suit.
My lord, here also mentioned no prosecution, suit or other proceeding.
No. That we are not convinced it for the moment. But yes, sir, if there is an income tax proceeding against you,
My lord,
with regard to the
if I
money.
may, the applicant belongs to the Mizo scheduled tribe.
Could be.
Mizo scheduled tribe.
Could be.
And resides in scheduled area in Mizoram. And her place of business is inside Mizoram.
Had it been an amount which we could reasonably assume to be proceeds of sale from what you said is a small grocery wholesale, things would be different. Now the issues will arise as to when it has been recovered from Burmese nationals. Is it?
Yes, of course. That's correct.
Whether the business or the income can be said to have generated within the provisions of the Income Tax Act to keep it out of the purview of the taxation, whether it has got a relation to some other source of income. We are not saying it's an illegal money, we are saying it is legal money. What is the source of the income and whether you are liable to pay taxes on it, and if not, what is the other course that has to be followed according to law. This has to be evaluated in the income, the proceedings taken up by the Income Tax Department.
My lord.
Unless that is brought to a closure by whatever means.
Yes, my lord.
Would it be reasonable to now release the money?
Yes, my lord, in my humble opinion, the applicant is not required to file income tax returns first, because she belongs to Mizo scheduled tribe and resides in scheduled area of Mizoram. And the place of her running her business is at Zaukothar, that is within the specified scheduled area, as stated under. Yes.
That is exactly why the proceedings under the Income Tax Act, whether this money has come from that particular business, whether there is some other business, whether you have got some international business, that is what they are trying to find out.
It is, my lord, she already established that her business is lawful business, and he took, may I take you to...
You may not be required to file a
may I take
tax
you to,
on the income. You may
Page
not be
40.
required to file a tax on the income generated within the territory of Mizoram. But with such a huge income, you are at least to disclose your source of income. The tax return has to be filed. You have not brought anything before this court to show that, yes, this is the level of my income and I am not required to pay taxes, sir. They are troubling us. That would have been a different aspect. Here you are saying that you have got some cash memos.
Yes.
CGM has the CGM, learned CGM before whom the cash memos were present, he has thought it fit not to trust them. How do we interfere in a criminal division on this?
No, my lord, she established her ownership since the very beginning.
Huh?
She established ownership since the very beginning and submitted all related
whom?
cash memos,
To
yes,
whom?
to the police and to the CJM. But
Where is that report? Where does the police say that this is a totally this income? We do not find anything illegal in this. Can the police find out what sort of an income is it? Anyway, where is it?
it's in
Page 27, in fact, says that
My lord, upon a
Yes.
notice served by the Income
yes,
Tax
page
Department.
27. Yes, page 27.
yes, Mr. Chetia?
My lord, in fact, my lord, upon a notice served upon sent by the Income Tax Department, where she has filed her reply and categorically stated that money does not belong to her.
Where is
Your
it?
lordship is my affidavit,
Is it
page
here?
22.
Page 22. Oh, sir.
Lordship. This is a typed copy of the my lord, original copy was also there, my lord. So, my lord, reference to notice number so and so dated 28/5/24 is invited. Query number 1, please confirm if the cash belongs to you. Therefore, first she stated about her business, then on the page 23, my lord. Second para. To answer if the cash belongs to me, I must first confirm if I have any debt receivable from the 3 individuals from whom cash to the tune of rupees 1.3 crore was seized. The answer is no. I do not know them personally or through contact or otherwise. However, as I have learned, the cash was meant to repayment of the debts owed to me by Miss so-and-so and so-and-so, through whom the goods are taken to Myanmar and the payment of which is sent to Myanmar. It may also kindly be noted that before this event, Mr. So-and-so and so-and-so have regularly been paying me in cash, but since the debts have already accumulated to a higher volume, I firmly believe I would be paid through any of the banking channels available to them, as dealing and managing large sum of cash is not something which can be taken lightly, and I was not anticipated nor prepared for. As they have made payments using banking channels, using their relatives' friends' bank accounts before, I had good reason to believe payment would be made in such a manner, whether in part or lump sum. So, to answer if the cash belongs to me, the answer is no, as the same has not been delivered to me in repayment of the debts of Miss so-and-so and so-and-so, and the mere intention to delivering the bulk of cash to me does not make it my property, yet if I have not taken possession of the cash.
You
So,
see,
my lord,
sir,
in
there
a
is-
proceeding initiated
They are
by...
just saying in English, you cannot have the cake and eat it too. You have to say it is my cash or you have to say it is
My
not
lord,
my cash.
the petitioner is IT literate. She has already established her ownership and she already claimed to the appropriate authority.
How have you
And
answered?
it is not improbable. It is not probable that she will deny the ownership at a later stage. If I can take you to my reply affidavit, I have clarified the
You
stand.
have denied this.
No, she did not deny it.
Then?
She is IT literate. I don't know. It is not probable that she already claimed her money to the appropriate authority, and while she had already claimed the property, it is not likely that she will send such email. My Lord, if I can, may take you to my reply affidavit, page 4. From page 4, para 8, from the bottom, if I may read. While the application of the petitioner seeking the release of seized cash to the competent court was still pending before the competent court, the respondents number 6 and 7 had no authority to conduct any inquiry or undertake a parallel investigation without a valid order from the court. And at para 9, the respondent number 6 and 7 claimed that summons were served on petitioner 3 times. That is on 25/5, 26/5, 28/5, all in 2024, within a span of 4 days. However, the petitioner was served a copy of the summons dated 28/5/2024 on 29/5/2024 at Champhai, wherein she was required to attend the office of the respondents number 6 and 7 at Guwahati on 29/5/2024 at 11 a.m. to give evidence and to produce, either personally or through an authorized representative, the books of accounts or other documents in her possession in connection with the said seized cash.
Yes, Mr. Chetia, from where do you have this email? This was sent to you by email?
Yes, Lordship. My Lord, may see the extracts of the email from page 19.
But from which email?
Page 21, bottom, Your Lordship, see the details of the mails, my Lord. It was dated, Lordship, 26/7/24 from this email address of the, my Lord, the petitioner to so-and-so, that is guwahati.ddit.investigation.fajau@incometax.gov.in. So subject was reply to queries under section 131. So it is in the official email, my Lord. There was notice served, my Lord. It was responded. She says this, my Lord, and it was a separate proceeding. And that separate proceeding is not challenged before this honorable court, my Lord. It was a separate proceeding, my Lord.
Yes, sir. A disposal today.
See,
or
my Lord,
an attempt on some other day.
My Lord, otherwise also, my Lord,
we'll
under
take it up.
section 293, my Lord, it's a specific bar. No, otherwise also, my Lord, under section 293, my Lord, it also refers to any proceeding, my Lord.
That is a disposal
All
today.
right, Your Lordship, yeah, we can take it up, continue at some other time.
Oh, we are not here till May 8th, so we'll not keep it as part heard. You'll have to try from the beginning again, if you want to. Otherwise, we do not find any illegality in the order of the learned CJM by which we can direct a release of the amount. At best, we can allow you to go and make a contest before the IT authorities. If that is provided for in law, give adequate surety and have your money withdrawn. If that is allowed by law. I do not know. Yes, madam, what do you say?
Yes, Your Lordship. In this case, now, the order which the appellant has challenged is a different case now. At the time when they submitted before the CJM, it was under the police case. And now the police has transferred the case to the IT section. And then there is a new investigation. So they have to face that new investigation, not the old one, because this is nothing now. And there is nothing to challenge in this
Since
order.
now the money is with the IT.
Exactly.
If it is your case that the income tax department is illegally withholding the money, then
My Lord, if it can be taken up at some other time, because right now I'm...
Yes, Mr. Chetia.
Otherwise, Your Lordship has substantially hard it.
The learned counsel for the petitioner actually wants the iron to be more red before he can hit it. We'll give him some more time to cook the...
Lordship may kept it part hard, my Lord.
Not till May 8th. We are not here for quite some time. So keeping it part hard is beyond it. We can give you the liberty. We can close this petition. We can give you the liberty to explore such other...
If it can be kept to be taken up at some other appropriate time again, my lord.
Okay. But this continuation of this petition is not helping you any which ways. It is only a pendency in the pendency before everyone. The order of the CJM, even if we set it aside, what is the best relief you would have? We cannot direct the release of the money since now it is with the IT department. IT department specific case is that I have got a investigation pending. Pendency of the investigation without you giving some surety or without there being a provision in law, can the money be released? This will prolong the agony of the petitioner. In my opinion, in my views. Is it not so?
If I may.
Please, please. We are always.
Since this matter has been brought before Lordship for the purpose of exercising the inherent jurisdiction, not as a revision of the order which was passed by the learned CJM, as to how it has been illegally taken up and how the orders have been passed. There is no other alternative except the provision which has been invoked for the purpose of exercising Lordship's inherent jurisdiction. So, Your Lordship, this may not be taken as a revision. We're not challenging the order of the
it's a criminal petition,
CJM's
even
order.
then.
Yes.
Even then.
For the ends of justice, since there is a shortage of time, Lordship, this may be fixed for another round on your next Lordship's visit. It may not be fixed as part. It may be taken up by a Lordship on your next visit, if possible.
But when the money is now required on an investigation with the income tax department,
In fact, there was no investigation as such.
they have given us, they've brought
What
on
they have
record.
done is that they have been informed by the police, and they have shown themselves of having met a charge,
And all that.
charge and all that.
That-
There
that-
was no charge.
That proceeding has to be challenged.
Yes, we're challenging that also.
That proceeding has to be challenged before we can say that yes, it has been illegally held by the IT department. A proper branch of the government has seized the money under specific applications being made to the CJM. That money has been allowed to be kept in the custody of the IT department. IT department is now initiating its
In fact,
own investigation.
all that has been seized by the police in connection with a criminal case will have to be under direction of the Honorable Court, the criminal court. But before anything was, passed, before any order was passed by
They
the
transferred the
criminal-
money.
They have simply transferred. A number of illegalities have been committed.
Okay, we'll simply say that at the request of the learned counsel for the petitioner, after some hearing in the matter, the learned counsel for the petitioner has prayed for some accommodation to further address the court on the issue. Accordingly, place this matter after 4 weeks, according the learned counsel for the petitioner, the time sought for. Mr. Chetia, we are
Lordship.
what do you say, reluctantly granting him some time.
Let them
My lord.
the money in their custody till then.
But the money remains in their custody till then. You take the attendances, Mr. So-and-so for the petitioner, Mr. S. Chetia for the IT department, respondent number 6 and 7 you said.
Lordship, 6 and 7.
Madam so-and-so for respondent 1 to 5.
1 to 5.
Thank you. Any other case? No? Thank you.
I'm obliged.